Any mention?
No mention. Yes,
Lordship. Lordship, I beg to make a mention of item number 5, Lordship.
Number 5 from the
Daily list, Lordship.
These are the income tax matters.
Lordship.
You for the other side?
Yes.
No objection?
No objection.
That means 5 and 6 also.
Lordship.
5, 6, yes. After vacation.
Obliged,
Right.
Lordship.
Daily list. Item number 1. It's for the union to file affidavit.
I'm praying for some more time.
Any urgency? This is an income tax matter.
No.
GST.
Yes.
This is GST.
Yes.
Yes. On the period of the Muzika and JCI, further 2 weeks time is allowed for affidavit. Just thereafter. And so on. So, yes.
Hearing. Supplementary list. Item number 1.
Ready?
Well, by tomorrow I'll give it to court master. I'm working on it. It has come, my lord, just to give finishing touch. And
Difficult, I know, yes. Dr. Muzika prays that we allowed a day's additional time to complete the written submissions. Praise allowed is this tomorrow, yes. That is over, yes.
Item number 2.
Item 2 main list, my lord. This is Khasi wine dealers.
Yes, where are we with this matter?
Yes, we have to file written notes, my lord. So written notes are
already
ready.
been heard.
Yes.
So you can't expect can't expect a judgment by tomorrow.
Yeah, I understand, my lord. That.
Where's
My friend was here.
you're there?
Yeah, I saw. I'm. Okay.
Lordship, please.
Most of all, your written notes of submission.
Yes, everything is ready. I'll just give it 2 minutes, my lord. Your lordship will be can take it end of the board if required, my lord.
You're already at the end of the board.
Oh, I just 2 minutes, my lord. That's
You can do one thing, but it's ready.
Yes, my lord. Everything is ready.
Yeah,
Everything is ready, my lord.
Then
Everything is ready. Only
I'll record that parties have submitted the written submissions.
yes, my lord. Yes.
Yes, hearings concluded, judgment reserved.
Yes, my lord. And all the judgments also, my lord, I have prepared. Everything is ready.
Very good.
Yes. That's
The written.
I'll just give him a copy sometime.
Yes, you exchange copies?
Yes, I will. I will.
You don't require any more time.
No, my lord.
Yes.
Thank you. I'll just give you a copy 1 minute. Wait for my lord.
Item number 2. Daily list.
So my docket is full window.
Okay. So item 2 and 3, my lord. Your lordship has heard us on item 2 and 3.
Today we have it's a bit difficult for us to take any final hearing matters. What are we to do?
So then it will go after vacation.
Dr. Saraf, I'm afraid we'll have to go after vacations because we have paucity of time.
I've submitted my written submissions.
Yes, yes.
I think
2 and 3 after vacations, yes. On the prayer parties. Number 4.
4 is different, my lord. Dalmia Cement issue is completely different from
Yes.
Mega Technical and JB Textile, my lord.
Yes.
It is.
this is also for final hearing.
This also will post it after vacations.
Yes, my lord.
Yes, how comes on the prayer of so list this matter after vacations, yes. Yes. We'll take up single bench. Yes. We'll take up those matters.
That supplementary one, my lord, Jorabat matter. Your lordships are having it tomorrow.
That's more.
See, Mr. Ghosh, the union is not ready with the written submission, so we're posting it tomorrow for submission of the same.
Well, it's only,
Very well, but
I'll give it to court master, my lord. It's not listed.
Today, you want to make any submissions?
Lord, today I have prepared a reply to the state's compilation, state submission, because they have made a reference to 3 judgments that was never argued. I have prepared a summary of that. Our
Then
contention.
what we'll do is
My lord,
we post it tomorrow. Then tomorrow you just complete all the submissions, so we can
Very
post
well.
it for judgment. Yes, even we can
Very
reserve the judgment. Right.
Very well, very well.
My lord, if my lord permit me to mention an unlisted matter, my lord.
Division bench.
Yes, my lord.
Which matter is this?
My GST matter, my lord. My GST has been cancelled, my lord.
When was it cancelled?
It was on 4th, my lord, 4th December.
Which we engage in what kind of business?
My lord, contractor, my lord.
Contractor.
Contractor, my lord.
Sorry, this bench not there tomorrow.
If I may pray, my lord, if my lord take up the matter today, my lord, if I humbly pray, my lord.
Why didn't you file it yesterday? Has it been filed?
Yes, my lord, it's filed.
When was it filed?
It's held today, my lord. Today morning.
Today. You mentioned for the Chief Justice where the bench is be constituted. Yes.
My lord. All right, my lord.
We'll sit again, single bench right now.
Any mention?
Yes.
Lordship kindly allowed me to mention for tomorrow, unlisted motion for
What
tomorrow.
matter? VEC?
No, Lordship. It's under SSA. We were appointed. We were promoted to the cluster resource coordination.
Yes.
Then out there,
Yes, 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 yes.
oblige.
Yes. 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 Item 39.
29.
29.
Counsel Mr. Guptamara is out of station.
Okay, yes. After vacations, yes.
Obliged.
Yes.
Your Lordship, I'd like to mention memo, Your Lordship. Your Lordship have filed an application yesterday, but you were informed that the matter could not be listed tomorrow, Your Lordship. So kindly allow Your
What
Lordship.
matters this?
It's a civil petition.
You find application a fresh matter?
Yes, Your Lordship.
List it tomorrow. Yes. Yes, yes.
May I please, Your Lordship?
Yes.
My Lord, I beg to mention three items, my Lord. 27, 28 and 30. These are connected matters, my Lord. 27, 28 and 30, my Lord.
Yes.
My Lord, here
I'm
what a petitioner, Lordship.
Mr. Sheikh, yes.
I'm representing MECL, my Lord, here. On the last occasion, my Lord, I have prayed that I'll be filing an affidavit, my Lord, and I even prayed the matter to come after vacation, my Lord.
You haven't filed affidavits yet?
No, my Lord.
Why?
My Lord, here, my Lord.
Electrocution cases?
My Lord, it is the FEDCO where the contesting party here. After the affidavit, my
No,
Lord.
we don't have time today.
Yes,
We press for time to have hearing matters. Anyway, we have to vacation. Expected that next year after should be on board.
My Lord.
Yes.
Your Lordship, I beg to mention item number 24.
24? Yes.
Can come out after vacations, Your Lordship.
On the joint request of parties after vacations, yes.
Obliged, Your Lordship.
Yes, just make it quick.
Lordship, I beg to mention item number 20. Let this matter come after vacation.
Rajiv Jeffrey Motho
Yes. Please, Lordship. No objection, Lordship.
after vacation.
Obliged, Lordship.
Yes.
Oblige, Your Lordship.
Lordship, but mention item number 32.
Number
32.
32. Helena Sangma, yes. You are appearing for the
BSF.
union. What about the state? What's the matter about?
It's matter about trading of cattle.
After vacation time.
Early leadership.
Yes.
Supplementary list, item number 1.
These balance.
Yes.
Well, we have before your lordships a very limited challenge. Now, the issue here, well, it pertains to a notification which has been issued by the state respondents.
Yes.
Purportedly exercise of powers under section 67(1) of the Motor Vehicles Act. Well, I've requested my friend. We've just kept copies of the act. Well, if your lordships, he can just pass it on. Well, we'll just expedite it rather than taking your lordships through the entire paper book.
Yes.
Well, it's under 67(1). We've got both the unamended provision as well as the amended provision. My lords, may kindly first have a look at the unamended provision. So, well, it's under the unamended provision, your lordships would have seen, it says that the state government, having regard to the advantages, my lords have it?
The Lordship will kindly have serial number 135 at the bottom of the page.
135.
We have handed over 2 sets of printouts. In the second set at the bottom of the page.
Substitute Act 30, 2019.
Yes, Your Lordship.
Yes.
No, I am referring now to the unamended millets. That's prior to the 2019 amendment.
Yes, yes. State government having regard to.
Well, it's the state government having regard to the advantages. Well, I'll skip all this. Now, I'll just read 1A, that the advantages offered by the public, trade and industry in the development of motor transport. And then, may come straight to subsection 1, which says, issue directions both to the state authorities regarding the fixing of fares and freights, including maximum and minimum in respect thereof for stage carriages, contract carriages, and goods carriages.
Okay.
So that was the position of law, my lords, prior to 2019.
Yes.
So 2019, my lords, there is an amendment which is brought in, and my lords may now kindly have a look at the amended provision, my lords.
Yes. Yes.
So under the amended provision, my lords, these subsection 1, 2, 3, my lords, they have been done away with.
Yes.
So in other words, my lords, the power of the state to regulate, my lords, freight in respect of interstate or intrastate my lords, transport of freight has been, my lords, withdrawn by the central government insofar as the act is concerned.
Now just read this 67(2). Now, direction 60, power state government to control road transport, the state government having regard to the so and so and so forth, from time to time by notification, issue directions for the state transport authority regarding passengers' convenience, economic competitive rates. Now 2, yes, come to 2. Under direction, just
any
read
direction, well, it reads, post amendment, it reads, well, any direction under subsection 1. Regarding the fixing of fares and freights of for state carriages, contract carriages, goods carriages may be provided such fares or freights shall be inclusive of the tax payable to the passengers so and so as the case may be, to the operators of the state carriages, contract carriages so and so under the law for the time being in force relating to tax on passengers and goods. And then there's a proviso, my lords, which says provided that the state government may, subject to such conditions as it may deem fit and with a view to achieve the objectives specified in clause D of subsection 1, relax any of the provisions made under this chapter. Now, my lords, the very subsection 1, my lords, has been amended to, my lords, negate that entire power of the state to fix freight insofar as, my lords, freight charges were concerned, because it has to be left open for, well, market forces would then decide this issue.
Okay, no, you mean to say 67(1)(d)?
My lords.
Yes. So what is your grievance? What has happened now?
My grievance is, my lords, now the state, if I draw your lordship's attention to the notification dated 5/12/2025, your lordships would find it at page 204 at NHA 29.
204.
204.
Yes.
My lords have it. Now, if they say, my lords, in continuation of the office order number so and so dated 2020 in pursuance of the minutes of the meeting dated 27 November 2025, I'll take your lordships to this minutes. The following rate shall be applicable with respect to the transport of cement within the state of Meghalaya. Now, my lords, they fix a certain rate, ₹9 per metric ton per kilometer for blacktop road.
Right.
Now, my lords, my contention is that this power to fix the freight charges is not existent anymore post the 2019 amendment. And that, my lords, I will point out, if your lordships kindly have page 199, these are the minutes of this meeting.
Yes.
My lords, your lordships have it. This is dated, my lords, the 28th of November 2025. Finals of the meeting held on 27th November 2025 at 3 p.m.
Yes.
Agenda item number 2, my lords.
Yes.
Fixation of transport rates by the Transport Department of the Government of Meghalaya.
Yes.
Now it says, my lords, the Commissioner and Secretary Transport informed the Transport Department has sought legal opinion from the Advocate General on the matter and requested Advocate General to brief the gathering. Advocate General informed that after the amendment of the MV Act of 1988 in 2019, state government is no more authorized to fix freight rates.
Yes.
Matter ends there, my lords. Now, in spite of that, based on this particular, my lords, minutes of the meeting, now fresh rates have been fixed by the state. Well, my humble submission is prima facie.
No, the only grievance is that now by market rate, the rate is at certain amount per metric ton per kilometer, right? Now what these truckers are asking for is that we fix 9 rupees per metric ton.
Mileage, what is happening is, I must mileage, make an honest statement before your lordships. It's a case of pure arm twisting by certain mileage organizations, and in spite of the knowing very well, mileage, that the state doesn't have the power for whatever good reason, the state is cowing down and then issuing these notifications.
Yeah, so they're asking for.
They are saying, mileage, that the state should fix.
What is the current rate now?
Well, it's the earlier rate is.
What's the earlier rate that they pay the transporters for transporting cement?
As on today, prior to the
prior to notification, how much?
Well, just bear with me for a second. My friend Mr. Aman is there, he can just give the court the relevant figures.
The rate was prior to this order, it was 7 to 11 rupees per metric ton per kilometer.
7 to 11 is flexible, but this is fixed at 9, it comes in between. Then? 7 to 11 means. 7 to 11 means there was no fixed rate. It is depended on the transporters, but it was between 7 and 11.
So that also allowed free market play. Now what happens is, in spite of
can there be a slab where it can't go below any minimum? Suppose you cartelize also regarding all 7 companies, they form a cartel and say we won't pay more than 4 rupees. Will the truckers be bound by that also?
But it's not a question of cartelization. It's more like this. It is a question of free market play. If I may just
because this Mr. Paul, this is confined. This is confined only to cement, correct?
This is confined only to cement.
Right. Okay, that's one point. Now the thing is that free market play means the cement companies are all paying uniform rate for transportation to these transporters.
As I submitted, it would be open to free market play.
But free market play means like if it's only cement from the company, then they also can cartelize the rate. That means. Correct.
Who can cartelize?
Cement companies, yeah. They'll have a meeting and say, okay, fine, we won't pay them more than that.
Rates by anybody. It doesn't allow cartelization.
Cartelization doesn't mean it'll be informal, it happens like that. So like, so plain fares. So that's why whether it's a slab or not, it cannot go below 7 rupees. Is there any, that it cannot go below 7 rupees? Is there any safeguard? Because 7 to 11. No, that is 7 minimum.
That was the position prior to 512. That's the position prior to 5/12/2025. Now, I am not on that balance. It's a pure legal challenge.
Yes, of course.
If you do not,
no, we understand.
In the first place.
Yes, Mr. Shulai, what do you have to say?
May it please your lordship. Lordship, can you have page 130A, your lordship? 12.
Yes.
If lordship, can you have a second paragraph from the bottom?
Yes.
Whereas the Ministry of Road Transport and Highways Transport Section Government of India issued a letter bearing number so and so to all the state governments citing a representation from Transport Association in respect of fixation of minimum freight price and requesting to issue appropriate direction in exercise of the power conferred under Section 67(1)(I) of the Motor Vehicle. So yes. This notification, your lordship, has been issued by the state, your lordship, in pursuance to this.
Where's this notification?
Lordship, it has been reflected in that order. And lordship, lordship,
you bring it tomorrow. We'll have it tomorrow.
Lordship, kindly have page 131, your lordship. 131, your lordship.
You bring it. You produce the notification tomorrow. If you are deriving your authority from some notification issued Ministry of Transport, how can it override the act?
The parent act, Mills.
Yes.
Lordship, for the moment, if lordship kindly have page 131A again.
Right. Okay.
Lordship, kindly see whereas both parties.
Where is that?
Lordship, 3, lordship, 3 paragraph at page 131A.
Yes.
Whereas both parties submitted their proposed rate in this meeting, and it was decided in the meeting that since both parties are not able to reach any common ground, the government may proceed to notify the rate for transportation of goods. This is by it's a mutual.
There cannot be any estoppel of law. What my learned friend is saying, sir, well, if the law does not provide.
They also agreed, Your
Merely
Lordship.
because two of us agreed, that would not enable the state government to issue any order. If there is any notification, my lords, let my
You come instructions tomorrow, yes. I heard Mr. K. Paul and counsel for the senior counsel with counsel for the petitioner issue notice. Mr. Andy Shurai, learned AG with MS Aling was present. No further notice. It's on behalf of respondents 124.
124, Your Lordship.
On behalf of respondents, notice to respondent number 5 to 16 to issue in the meanwhile. Stop the grievance of the writ petitioner, which is stated to be this is a conglomeration of cement manufacturers. Is with the rate prescribed by the state respondents, which is by way of notification dated 5/12/25. It is contended by the learned senior counsel that the state government has no power under the Motor Vehicles Act, more particularly Section 67, to prescribe such a rate. Stop. Mr. Andy Shriland AG, however, has submitted that the fixation of rate was also pursuant to a notification dated. Where is that you just now?
Lordship, kindly have one.
No, we're not going anyway. Just give the date because we are short of time.
RT 20th/7/2020, Your Lordship.
20th/7/2020. However, it appears. Stop. Mr. Andy Shriland. Yes, however, he submits the same not unrecorded petition stuff. Next paragraph. For further clarity of the matter, post this matter tomorrow in the motion column. The learned AAG to produce all relevant material in support of the fixation of the rate by the state government. Yes. Tomorrow, Mr. Paul, let him come. Yes.
I'll
Item number 2.
May it please, Lordship.
Yes,
This is a pension matter, Lordship. The petitioner retired from PWD department in 2021, Lordship.
While working as?
He was working as DUF 3, Lordship. But his pension has not been released.
Regularized?
He was regularized, Lordship.
Yes. Heard Mr. S. Pandey. Not paid till now.
Not paid, Lordship.
Issue notice. Mr. Kimi Barasaji. All. Yes, except no, we have all respondents. No further notice called for. Just after vacation for instruction affidavit. Yeah.
3.
Item number 3 is SOP matter, Lordship.
SOP usual order is.
Obliged, Lordship.
I'm appearing on behalf of the state respondent.
Record name of AG and number 3.
4. 4.
This is for 4th. Is this for 4th February? Correct? All the matters. Yes. 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 What is this?
Your Lordship, this is a petition pertaining to regularization.
To?
To regularization. Your Lordship.
Regularization?
Yes, Your Lordship.
In which post?
Your Lordship, she has been working as a sweeper in Markasa PSC.
She's still working now also?
Yes, yes, Your Lordship.
And we heard MSADCM, then counsel for the petitioner. You're accepting notice?
Please, Lordship.
Present, accept notice on behalf of all the respondents. No further notice called for. Let's after vacations for instruction activities.
5.
Wait, Lordship.
Yes.
Well, this matter pertains to.
I think I can't take this matter. If this name is familiar.
To me also it appeared familiar.
Yes. Yes, this is a matter when you bunch around me.
6.
Yes, Mr.
Well, not short issue involved in this case. The petitioner was following his suspensions. Now 5 months has been passed, nothing has been paid. Only for payment of the substance allowances.
When was he suspended?
Suspended in the month of July, but the order of taking effect from the month of March. Till the month of June, they have paid me full salaries, but after the month of June,
where is the suspension order?
Suspension order page.
Page
25.
25.
Yes.
Stop. Heard Mr. S. M. Suna, learned counsel petitioner, issue notice. 1 minute. issue notice, Mr. Belay. Mr. H. Abraham is present, accept notice on behalf of
1 to 3, Your
1
Lordship.
to 3. No further notice on these respondents. Notice to
private respondent,
number 4 within 3 days. The grievance of the writ petitioner is that uh, the writ petitioner who's serving as a teacher in the respondent number 4 school was suspended right order dated
7 April 2025.
7 April 2025 and was formally placed under suspension with effect from
March 10.
3 2025 to 10 5 2025, which was followed by another order dated 24 6 2025. Stop. A learned counsel pressure submits that though for the initial period of suspension the petitioner was paid subsistence allowance, however, after the last order dated 24 6 2025, the subsistence allowance has not been released, which has put the petitioner in great financial difficulties. He prays that appropriate orders be passed at the stage itself, that the substance allowance be released to the petitioner. Stop. Mr. H. Abraham, appearing for the this 1 to 3, please will have to obtain instructions and to file affidavit. Stop. On hearing the counsel of the petitioner and on also perusing the order of suspension dated with the last order
page
24 June 2025, it is seen that it is correct. At 125, the petitioner, it appears, has been paid suspension. If the submissions of if the contention of the counsel for the petitioner is correct, then respondents are directed to release substance allowance as admissible at the earliest. We just break and we'll come back. Now no more interruptions after intermission, yes.
Item number 7.
Yes. Yes, what is this?
May it please, Your Lordship. Your Lordship, this matter pertains to the illegal and arbitrary actions perpetrated by the respondent number 3, 6 and 7. So what happened, Lordship, in this matter is that the petitioner is the owner of a plot of land. And Annexures 1
3,
to
6 and
7.
7 is?
Number 3 is the state
Director of
respondent.
Tourism?
Yes, Lordship.
How can he be a perpetrator?
Lordship, what had happened is that the petitioner is the landed owner of a plot of land, and now the respondent number 3 has arbitrarily started construction of a tourist attraction on the petitioner's land, and the land has been used by the petitioner since the 80s, and he is deriving his sustenance from the land itself, Lordship.
What do you mean? Let's see. Who's up on the other side? Where's the state? Yes. You are?
I am petitioner, Lordship. So annexures number 1 to 7.
1 to 7?
Annexures number 1 to 7 documents are my ownership and have continuous possession of the land, Lordship. There's a NOC, and there's intimations from the Dorbar Shnong Dong Shiliang as well, Lordship, which shows that I have
this Kong Labi Pors
Lordship.
In the sale deed, who's this Lapi Pors Imle?
Lordship,
he's the seller.
She's the seller, Lordship. My father had acquired the land by way of sale, Lordship. My father had acquired the land by way of sale, and the sale was confirmed by the CM as well, Lordship. And I have been in continuous possession. And on that land, Lordship, what I've been doing is...
Yes. Please keep the noise down. Sorry. Yes.
Lordship, and on that land I've been deriving my sustenance by way of fisheries. I maintain a fishery pond, Lordship, through a registered society. The society has been registered, and the governor has also assented to the exemption of the land from coming into the purview of the Land Transfer Act when I had utilized the land for fisheries, Lordship. Now what had happened, Lordship, is that in the month of October, the tourism department had started construction of a tourist attraction out there. And after my fact-finding mission, I found out that it was the respondent number 6 and 7 who had actually granted the NOC. Now 6 and 7 are Mausanram village, Lordship, whereas my land is in Dongshiliang village.
No, now the construction is complete.
No, Lordship, construction is not complete, it's ongoing. Now the pictures, I have annexed pictures.
What
Lordship.
are these pictures?
The pictures are page number 46, annexure 8. Now the pictures depict that there are certain sheds which have been used, which are being constructed for the for stays of the laborers out there. And on page 47, Lordship, the last picture shows that the construction has been carried on.
How do you say this is on your land? How can we verify?
Lordship,
just by these pictures.
Lordship, if I may take Lordship to page number 68, Lordship. Page 67 is the no objection certificate issued by the CM.
Page 68, yes.
68 is the translated copy, Lordship. Here, Lordship, it shows that the schedule of the property have been well defined, and the tourist attraction falls well within the land.
So how do we verify that on just by your you're saying that it's within your fish pond is still existing?
Yes, Lordship.
It's still there.
It's still there, Lordship. And what had happened?
Then there's a civil dispute.
No, Lordship. What had happened is that
you have to file a suit against the state to injunct them against. Then why have you come by repetition?
No, Lordship. But what had happened, Lordship?
When the construction started?
Construction started somewhere in the month of. Had started sometime in the month of October, Lordship.
Then how?
So representations have been sent, Lordship, to the. But what had happened after that is that the respondent number 6 and 7 were the people who had given the NOC, to the tourism department, and after my objections and whatever I had done, Lordship, to try and stop the construction, they harassed me, and after harassment on the 4th of 11, 2025, they nearly beat me to a pulp, Lordship.
Really beat you to a pulp?
Yes, Lordship. So what had happened? Apologies for the informal language, Lordship. But what had happened?
They assaulted you?
Yes, Lordship.
Yes.
They assaulted me. After being assaulted, Lordship, I was barely able to escape with my life. And because of all these things,
where
which
is that
happened,
medical report?
FIR is registered.
FIR has been registered, Lordship.
No medical report. You said you assaulted.
Yes, Lordship.
Grievously. Is here medical report?
Yes, Lordship. The medical report has also been annexed. The medical report from the CHC is at page number 59, annexure 11.
59.
Yes, Lordship. This is the medical report from the CHC Maus and Ram. Because of the extent of the injuries, I was referred to Civil Hospital Shillong, and all this has stemmed because
See, Mr. I mean, how can you just person be assaulted just like this?
Yes, my lord. That is completely, and that's why FIR.
Now, what is the FIR says?
FIR, my lord, is at page 56.
So they stopped the work.
So therefore the accused have been named in that, my lord.
Have they been apprehended?
No, Lordship, no actions have been taken, Lordship.
That is a separate
petition.
No, Lordship, that is
not the
contention, Lordship.
That is not the petition, my lord. That is petition is only in respect of the land dispute between
Lordship,
the 6 and
You
7.
don't mind being beaten to a pulp.
Lordship, I do, Lordship. But because of what had happened, Lordship, because I'm deriving sustenance from there, I am deprived of my livelihood.
What to do with
My lordship, kindly see the problem which I feel, your lordship has rightly posed those questions, my lord. If your lordship will, those issues were there in my mind also. Page 10, if your lordship will kindly see page 10. Now, direct the respondent number 3 to stop all construction activities on the land of the petitioner until due process of law and permission have been acquired by the permission have been acquired from the petitioner. So, what is the case of the petitioner before your lordship is that the work is going on his land. That is his contention, my lord. If your lordship has seen those details, my lord, that is the only issue which has been placed. And if your lordship will see those
FIR, nothing is said here.
That is one of the prayers, Lordship. That is not the complete case of the.
Where is saying?
In prayer 2 is your lordship will see prayer 2 also, my lord. Direct response 6 and 2 sees and all anti-social activities. And 3 is 2 and 5 to ensure business activity of the petitioner, and directing 3 to bear the cost of litigation. So, my lord, the issue before your lordship is only in respect of land disputes between this construction.
Has any non-FIR case been registered with regard to encroachment?
No, Lordship.
No, nothing is nothing.
No. What's the new section now? Like 145?
No, sir, 145 CRPC. Now it's 145 CRPC. Breach of peace.
What is it now?
No, nothing has been done, my lord.
Nothing has been done, Lordship. No, FIR case.
Then what is the new section now?
Yes.
145. 145. Breach of peace, my lord, and it go to the SDM.
Because once he make complaint, then the SDM has to. He has to, put in an inquiry, and then
restrain the parties from.
Yes, from. We'll direct us accordingly.
Yes, Lordship. Nothing has happened, Lordship. Nothing has happened.
Okay. Heard Mr. LCA minute counsel for the petitioner. You should notice Minute Advocate General is present with MS Arconi, GA, on behalf of respondents 1 to 5. No further notice on these respondents. Notice to go to the respondent number 6 and 7. Stop. Minute Counsel Purchase is by way of the instrument application, the writ petitioner who stated to be you're a president of cooperative society.
Yes, Lordship.
President of
not the president, Lordship.
All these facts are disputed with us.
Personal.
I've come as on a personal capacity, Lordship.
Who said to be where's your identification? Who states
at paragraph
the petitioner who stated to be the owner of a plot of land situated at Dongshiliang village.
He is claiming, my lord, that and that is also based on, if your lordship will see, Kacha deed of declaration.
Stated to be. So
stated to be.
Is agreed with the action of the respondent number 3, as also number 6 and 7, which he alleges are seeking to set up. What are they setting up?
The respondent number 3 is setting up a tourist attraction, Lordship. We are not
tourist
clear.
Attraction.
A tourist attraction. We are not clear as to what it is.
A tourist.
It looks like a viewpoint, Lordship, as per the instructions which have gone.
But setting up a tourist facility within the land of the petitioner, and the same has, without any due process of law.
That has been refuted by me, my lord. That has been vehemently denied.
Anyway, here's a submission. It is also further submitted that the respondents number 6 and 7, due to the objection of the petitioner to the said construction, assaulted him on
4/11/2025.
4/11/2025, 2025, for which an FIR has been lodged with the Ram police station.
Yes, Lordship.
Ram police station. He prays that at this stage he may be given some protection, and that the respondents be directed to not. You're asking not to cease all construction activities which he claims are being which he claims being done in his land. Stop. The learned Advocate General, appearing for the state respondents 1 to 5, submits that the matter is purely a civil dispute for which the writ petitioners are at liberty to institute appropriate proceedings if the allegations made are correct. Stop. He further submits that with regard to FIR, a case has been registered and the law will take its course with regard to the perpetrators or the accused. Stop. We submit that should go to the SDM.
164, if the 164 my lord BNSS is there.
You get very confused in new sections, you know.
Yes, that is the problem, which is the yes, my lord, because 164 says that if the procedure dispute concerning land or water likely to cause breach of peace.
Yes.
So 164 here, one BNS. Yes, give me this is the
yes. It is first submitted, but that so submitted by the Advocate General that at the most submitted that as there is likelihood of breach of peace law, there is enough provision, and there is provisions in the in section 164 of the BNSS 2023 to allow the authorities to take action. On hearing the counsel of the parties and from the pleadings as contained in the writ petition, as also the lectures annexed thereto, it is seen that the claim of the petitioner is based on certain land documents and also the registration of a cooperative society. It is also noted that certain photographs have been annexed which show some construction activity, but which cannot be verified at this stage by this court sitting in writ jurisdiction. However, matter of concern is with the assault that has happened, which surely points out to the existence of the possibility of a breach of peace and also the dispossession.
My lord, disposition is because disposition is problem is, my lord,
if the petitioner is the rightful owner of the property, and these circumstances, in these circumstances, as this court cannot discern, cannot in these circumstances, in the presence of disputed facts, but it will not be possible for this court to render any conclusive finding with regard to the ownership or possession of the petitioner. And as there's a possibility of a breach of peace, it is directed that the subdivision magistrate,
executive magistrate 164 now is using
the magistrate of Ram subdivision, subdivision shall take appropriate action under section 164 164
of BNSS, my lord.
of the BNSS and to cause inquiry and to ensure that law and order is maintained. Yes. We'll dispose it off.
Lordship,
And with liberty to, if he has civil case.
Liberty is also provided to the petitioner to take recourse to civil remedy.
Yes, in accordance
with these directions, the writ is disposed of. However, it is expected that on receipt of this order, the SDM will take prompt action.
time frame may be provided, Lordship, because I derive sustenance from the...
So prompt action, he'll take it, then you make application.
And application, and the order has to be served on the executive magistrate
Yes, you
also.
served order.
That order has to be served.
Item number 8.
Obliged.
8.
Yes.
What is this, Mr. Moment?
May please your lordship. Lordship, the petitioner here, my lord, is the Nokma of Napaka, my lord. In the year 2022, my lord, the forest department, my lord, erected a structure, my lord, a concrete structure, my lord, in the year 2022. So signboard within the Akang, my lord. So we file an RTI, my lord, and the RTI clearly reflects that no portion of the Akang was ever declared as reserve forest, my lord.
Where is that?
Here, my lord, kindly come to Annexure 5, my lord, page 27.
What about this Annexure 4? Songsak Reserve Forest starts at Rongre?
Yeah, this is the structure, my lord.
Then?
This is the picture, my lord.
It just defines the...
Yes, my lord, but this has been recently, my lord, in the year 2022, my lord. If lordship sees the picture, my lord, it's a new structure, my lord. It's not an old structure.
No, structure new, but then the Gazette notification of 1883.
Yes, my lord. 1883, my lord. So in the year 1883, if they have already demarcated, my lord, coming within my Akang,
how do you see
it's unwarranted, my
lord?
lord.
It's within this latitude and longitude.
No, I'm saying that it's not, my lord.
Now,
now it is within my Akang.
Tagging of your Aking then.
Yes, my lord.
You see the counters. You take notice.
Lordship.
Yes, I heard Mr. E.G. Moment and the counsel petitioner. I should notice.
I'm for 5, 6, and 7.
Yes, Learned Advocate General with so-and-so is present on behalf of respondent number 1 to 4, and Ms. S.D. is present on behalf of number
1 to 4.
5, 6, and 7. So no further notice required. Just after vacation, you geotag your Aking.
Now
geotagging. You can geotag it and you get the coordinates, and we'll know.
Yes,
if it falls within those coordinates, then
no, that is what, my lord. I've already submitted representation. They are not replying, my lord.
With geotagging?
No, I asked, my lord, but for inquiry, but they are not doing anything.
GPS is very simple.
Yes. Hello, my lord.
Yes.
9.
What is this, Dr.
But this is a VC matter, my lord.
Who's for the caveator?
I'm for
the caveat petition.
We have served the caveator.
I'm for the caveator.
I already arrayed this party.
Yes, my lord. And we have served no
seen the
copy.
caveat petition filed by. Seen the caveat petition. Stop. Mr. S.K. Hassan. Number?
My lord, 7, 7 and 8, my lord. 7
filed by the caveator, who's been arrayed as respondent number 7 in the petition, represented by Mr. S.K. Hassan. Caveat stands as charge. Yes.
Now, my lord, in this case, page 17, my lord, is the notification by which the election process was started, my lord.
17?
Yes, my lord.
This is 31st October, yes.
So, my lord, by this notification was issued, there was no verification of job card holders done before announcing this election.
No verification done?
My lord. Now,
then
our grievances, my lord, elections were held on 17th of November, my lord. And
they've been approved.
And 20th, my lord, page 20, this is 25/11. Results were published, my lord.
Yeah.
Approved. Now, at serial number 2 is respondent number 7, my lord, Meera Rani Das. She is elected as secretary. Now, my lord, the petitioner, there are two petitioners, my lord. Petitioner number 1 lost by 2 votes, my lord, to her.
By 2 votes?
By 2 votes, my lord. And
petitioner for the post of?
Secretary, my lord.
Okay.
And petitioner number 2 lost by 59 votes, my lord. We have stated in the pleading, my lord.
For secretary only?
Yes, my lord. Now, my lord, kindly see.
Yes.
The same video, my lord. This is with regard to Rajawala village under Batabadi CNRT block, my lord. There are lots of see at page 20, my lord. Batabadi CNRT block, West Coast of Meghalaya. Now same video for other villages, my lord. He is asking for verification of job card holders, my lord, and indicative orders are.
But how do you say there's been no verification of job holders?
There was no verification, my lord.
Is that,
and that's one aspect, my lord.
I have received instruction yesterday night, my lord, from my client. The petitioner herein, her husband was the previous secretary of the Rajawala VC, and the door-to-door job card verification was conducted in presence of the previous VC secretary, my lord. As per my instruction, my lord.
Who's the for the state?
Yes, doesn't for the state. The job, the verification was done.
You got instructions.
I got the instruction, but I could not get the date. No, when the
you get it by tomorrow. We'll post it. It was not done. We'll suspend.
Not only that, my lord. The returned candidate secretary, my lord, is not even a resident of the village.
My lord, the previous no, my lord. She was married to one person, my lord. She was from another place. It's correct, my lord. She came to Rajawala.
She's from, oh sorry, this
Mira Rani Das,
she's from another village.
Another village. She came to Rajawala by marriage, my lord. And her name was included in the job card.
And epic card still of the other old village.
But other old village, my lord. But it's still not yet transferred,
but
my lord.
Is she eligible?
Yes, my lord. The requirement to stand in the election, my lord.
Who is eligible to stand for secretary?
My lord, only requirement is his or her name should be there in the job card, my lord.
Well, kindly see page 64, my lord. I'll just point out what the government is also doing, my lord. Page 64 is the family card, my lord.
Yes.
And you see Rahul D. Sangma, Fatima D. Sangma, and Mira Rani Das. They belong to the same family, my lord.
Yeah.
Now next page, lots of kindly see. 2 pages after that, page 66, my lord. Yes. This is a marriage agreement between Rahul D. Sangma and Fatima D. Sangma. So how this lady is a member of that family, my lord?
By marriage, my lord. She
married to whom?
Married to Rahul Di Sangma.
Then he's married to someone else?
No, my lord.
Fatima Di Sangma.
My lord, what happened, my lord, the Rahul Di Sangma, his father was a Muslim, my lord. His mother was a Garo lady, my lord. And his name
was named Rahul then?
My lord, that I have no idea, my lord. They kept the name as Rahul, my lord. Yes. But the respondent number 7, Mira Rani Das, she married to Rahul Di Sangma. And when they married, my lord, during their marriage, her name was changed to Fatima Di Sangma during their marriage time.
Then how she contested as
Fatima, same person?
My lord, same person.
Then how in this job card is showing?
Then in the job card, my lord, in the job card, they have accordingly entered in the job card, and then
there's
my lord,
something very strange. Look at the job card. Fatima Di Sangma shows 19-year-old female.
My lord,
and Mira is a 29-year-old female. How can we be the same female?
Some discrepancy maybe on the part of the block development officers during the enrollment in the job cards. My
lord. Get the time, but tomorrow. Otherwise,
yes, yes.
So issue notice. Mr. H. Abraham, present. We have respondents number 126. Respondent represented by Mr. S. Hassan. Notice to go to number 8.
Yes,
however, this is a matter tomorrow for instruction.
8, I think Abraham left.
No, I am 1 to 6. 1 to 6 is a statement.
But however, it is the matter tomorrow for instructions by the state respondent.
But 7 and 8 he is appearing.
7 and 8.
Yes, ma'am. Caveat, ma'am.
7 and 8. For 7 and 8. Notice is complete. It is a matter tomorrow for instructions.
Hello.
Very strange. How can that same person be 1929 at the same time? He's VC man from there. Very, very strange.
Yes. Deeply obliged.
May it please your lordship. This is a matter pertaining to illegal transfer of land, I say, on the basis of the pleadings. The respondent number 5 has been allotted some land to set up a cement factory. Now, I understand from the information that some parts of my land has been transferred in favor of the respondent number 5.
Who's respondent number 5?
Respondent number 5 is Sri Cement Factory. The lands in question belong to me which I had purchased, and patta was also issued in my name. But the respondent number 4, who is the Elaka Nonclave, they did some mutation in between and got some parts of my land transferred into their favor, mutated into their name. And the respondent number 4 transferred it to the respondent number 5. Thereafter, my lord, the Pollution Control Board has issued a public notice requiring a public opinion and expression of objections on the aspect of environmental clearance of the matter. Having come to learn that, my lord, I file representation before the Deputy Commissioner as well as the State Pollution Control Board, saying that the area over which the cement factory is going to be set up, part of it belongs to me. The part of the land belongs to me. So don't go ahead with the proposed public meeting, which is scheduled to be held on 19th.
How are you so certain that the cement factory will be located in your part of the land?
Now, there is a state.
Where is that? How you, on what are you basing your case?
Well, the basis of my case, my lord, paragraph 7, I have stated in page 7, my lord.
Yes.
That I have the pattas registered to my name, which was long time back in the year 2009. And now the Elaka Nonclave, which is the respondent number 4, they have mutated a part of this land in their favor.
This is issued by whom, the patta?
The patta has been issued by the District Council, my lord.
Are they party here?
Elaka head is party, my lord.
Elaka head is party here.
They're the persons who issued the patta, correct?
Yes, my lord.
Elaka head is party here. And the Elaka Nonclave respondent number 4, my lord, they have issued the they have transferred the land.
Your case is that you have this certain parcel of land, correct?
Yes.
Where you have patta issued by the district council,
yes.
Correct?
Yes.
Now, you are saying that your land has been illegally mutated in the name of respondent number 4.
Yes.
Who has in turn transferred it to respondent
number 5.
Without your knowledge?
Without my knowledge and consent.
No consent without your knowledge.
Without my knowledge.
Without knowledge. So then now that the factory is proposed to set up in that parcel of land itself.
A part of not entirely on my part of land. Part of my land is included therein.
And then public hearing has been fixed.
Public hearing has been fixed on 19th.
For the purpose of?
For purpose of assessing environmental aspects, my lord. They say that only with regard to the, if your lordship will kindly see.
With regard to the,
if your lordship will kindly see.
Where does your patta, when is it issued?
My lord, the pattas are in Annexure 2 onwards, your lordship will find. Page 16.
Okay.
Page 20 is the patta granted to me.
16 is the sale deed.
16 is the sale deed, my lord. And page 20 is the patta.
No, 22.
Annexure 4. And it has been translated, my lord, at page 22. And the next patta is at page 23. The translated copy is, my lord, at 25.
This is dated when, this patta?
Well, date is not
page 20?
23.
Page 20 is one patta, my lord. The date
Dated
is,
when?
Date
This
is
is
not.
referred to the same plot of land.
Well, here in the public notice, my lord, there is no description of land given. Only the Elaka is mentioned.
Then?
And thereafter, my lord, it has come to my knowledge because of my inquiry conducted.
No, but you are aware that your parcel of land has been remutated in someone else's name. That is your contention.
That, yes, that has come to my knowledge.
You
now.
have recourse to other remedy under the land revenue regulation. They've adapted to a certain extent.
Yes.
And you are this DHEDC also. You should array them as party, in fact. So the thing, they are the persons who see whether in your landlord cancellation of your patta, whether someone else has been issued, number one. Number two, now what's your grievance with the... It's not a question of setting up, it's only a pollution hearing.
No, they are going to set up because the project clearance has been given.
Pollution...
only the environmental aspect is to be assessed now.
Yes.
If your lordship will kindly see page 14, Annexure 1. It is brought to the notice of all concerned. My lord, may I just read it? Page 14.
Yes.
It is brought to the notice of all concerned that Messrs. So-and-so has proposed to set up an integrated cement plant with capacity so-and-so. Now, if your lordship will kindly come to the last but one paragraph. In this regard, Meghalaya State Pollution Control Board invites suggestions, comments and objections on the matter relating to environmental aspects of the proposed project from all local affected persons and others who have plausible stake in the environmental impact of the project. Now this comes to my notice and thereafter I file objections. Although these are not related to the environmental aspect, but I say that the ownership is disputed and therefore don't go ahead with that. Your Lordship will kindly see page 27.
Please JHDC also.
Yeah, my lord, just give me 2 minutes. Well, I will show how he has been set up in the entire process, my lord. Kindly see page 14. Certain things have not been. Let him finish. I am waiting for my chance. Certain things have not been said. Attempt has been made to mislead this honorable court. I will show that.
May kindly see page 27, paragraph 5. This is how I express my grievance before the respondents, Deputy Commissioner and the Pollution Control Board. Paragraph 5 at page 27. It has come to my knowledge that the Elaka authorities have purportedly handed over land falling under my Patta holdings in favor of the cement factory for establishment and related activities. However, these lands properties are privately owned and are as per valid Pattas and land documents issued with under due authority and without notice, consultation or opportunity to be heard was given to the landowners, snatching away the right of the landowners. Therefore, the Elaka has no jurisdiction to alienate, transfer, allot or interfere with the Patta land under individual lawful ownership, and such action constitutes a violation of customary land rights, established land laws and principles of natural justice. Therefore, I request that don't go ahead with the public hearing. Let this aspect of the matter be inquired and decided, and thereafter you may proceed. That is my grievance.
If your case is that only in a portion of the land, maybe it's just environmental hearing. So maybe it might not be feasible. Maybe in the hearing they say no. How do you know?
But then the clearance has been given. The
clearance is there. Been given. Environmental hearings, public hearing is there.
My anxiety is
until the final permission comes and the definite boundaries are not given here in the notice also where it's being held. It can be held in. Given the location, only the village location.
My limited prayer is this, my lord. Let the authorities take a call on my representations. They let them decide this representation in one way or the other.
Let's see
at least. Yes, your lordship. Kindly see page 14, my lord. Just see how this person has been set up, my lord, and how he is trying to sabotage the project.
14 is a pollution.
14, and kindly note this, my lord. Located at the place, my lord. Only for Khara Siang Lam Pirsim in Dastong village. Yes. The project is at Dastong village, my lord. Yes. Now, kindly see his pattas, my lord. First patta, he is not original patta holder. What he has set up a case, my lord, before your lordship. Kindly see the annexer. If I can show from his own pleading, my lord. Just see his pattas. The area is where, my lord. Kindly see the area of the patta also. And this is also not a patta. There are two pattas. If your lordship will see page 22, 600.
Number of patta.
Yes, there are two number of patta. There are two pattas, my lord, 600 and 1462. That is, I will place first 600, my lord. Now this is the patta given to someone else, my lord, and he says that I have got this patta in gift from the daughter. But area, just for the sake of the area, my lord, name of Ilaka, my lord, Nonkli.
Yes.
And then name of land with boundaries, Madan Rasboom.
Page 20.
Page 22, my lord. In 20 is your lordship will translated copy is your lordship will find. This is the patta. This is not a patta given to him, my lord. If I can show the terms of this patta also, my lord. 22, my lord. Kindly see the patta 600. Public shall have right of passage. Residents may use small so and so. And the one, my lord, occupancy right over parcel of land is confirmed stated without payment of land. And and this is the your lordship has seen. And the area also, kindly note down, name of the land with boundaries is Madan Rasboom at the bottom of page 22.
Who's Mr. Tospala?
Tospala is my predecessor in interest, my lord. I have purchased it from her.
And then I will come to that also, my lord. Just give me one more.
You can continue.
My lord, this is all fraud which is being played on the court, my lord. That is what I can see. And then your lordship will see page 25 again.
Yes.
This is and then from him, my lord, this is 1462. Area also, for the sake of area only, what is the boundary and where my hearing is going to take place now.
Where 25? Where
25, my lord, Madan Flang Mopai was boundary, my lord, and area of and then if your lordship will see the pleading, just see the pleading. What he says that he doesn't have anything. What he's because in 2022 some gift deed, my lord. Just see his pleading, my lord. 2 paragraphs more by paragraph 4, my lord.
Yes.
At page 5. It is stated that petitioner is the landowner of the 2 plots of land, namely Ka Madan Rasbung and Madan Siv Kubul, situated at an Ilaka Nonkli, East Jantia Hill. Ilaka Nonkli, my area, your lordship, has paragraph 4, page 5, my lord.
Yes.
At Ilaka Nonkli, East Jantia Hill, wherein applicant purchased these 2 plots from Srimati K. Sadab, white Kacha seal dated 16/9/22. There is no, is not permissible, my lord. The land is disputed transferred by her father, Toss. Your lordship has seen Toss, a resident of so-and-so, by way of gift deed dated 3rd February 22, and boundary of those areas, my lord, Madan Rasbung. This is nothing to do with the site, nothing to do with the area, and these gift deeds have been created by him, my lord.
Who is he?
I don't know, my lord, that, and this is a
warrior.
And your lordship will see this is a project entailing, my lord. I went to the website, I saw 1250 crore rupees of investment which is going to come.
That doesn't matter. Only thing is a public notice.
And public no, and
we can't go into this facts with regard to.
Yeah, my lord, and patta and give deed and kacha sale.
See, Mr. Datta, you are interested only in stalling this hearing, right?
Yes.
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 That won't happen.
My limited submission is that
until you make a watertight kind of prima facie case that yes, within these this is happening and then it's imminent, that will be clear. So this only thing.
No, my only
and this is
only
set up by other persons to stall the public hearing.
Go there. We just going
because
by what's
and why, my lord, your lordship will see the right now. Once the public hearing is there, he says that I have got the gift deed from the original allottee, and on the basis of gift deed, that is also not registered. Nothing, no permission from district council. NOC is there.
No, his
and he says also
other contention is that this 2 parcels of land, whatever, has been illegally mutated in favor of the.
Where is that? Where is that?
I could not annex it to the writ petition, my lord.
And paragraph 10, your lordship, kindly see one paragraph.
Today, my lord, this morning, if your lordship will kindly
this morning
allow, yes.
Kindly see paragraph 10, my lord. Kindly see paragraph 10, my lord. Kindly see paragraph 10.
Where's the tree?
Paragraph 10, my lord. Kindly see it will belie his own case, my lord. Paragraph 10, my lord. Paragraph 10 at page 8.
Yes.
He says, my lord, that he could not get the document, etc., my lord. He says he's all making false case before your lordship.
No, my limited submission is that the authorities should decide the matter one way or the other.
Because
what prevents the authority from deciding it?
He is not filing a case before the authority, my lord. He is filing a writ petition for objection to the hearing, NGT, the EIA. He is not filing a case that this is my land and this land has been wrongly transferred. He can go and file it before GHDC. He is not doing it. GHDC is not made party. At just 2 days before 19th, my lord, he comes before your lordship for stalling the hearing, my lord. Kindly see his conduct also, my lord. That's a thing which your lordship noticed that, and it is a public project, my lord. And
heard Ms. S. Datta, Learned Counsel with the petitioner, General Counsel assisted by Mr. Aida. Stop. Issue notice then Attorney General with MS S. Lalu is on behalf of the respondent 1, 2, 3, no further notice to respondents. Notice to go response 4 and 5 within 3 days. Stop. The writ petitioner is before this court with a prayer for issuance of a writ of mandamus directing the respondents not to process, grant, or issue any environmental clearance consent / by clear number B to establish in favor of respondent number 5 over land state to be disputed, and an interim prayer has also been made staying further processing of the environmental application for any construction activity on the disputed land. Mr. S. Datta, the Senior Counsel, has submitted that the respondent number 5 is the number 5 is a cement company which is proposing to set up a cement plant at Ileka Nongkle, which is under represented by the DOI as respondent number 4. His main contention rests on the fact that in the proposed location of the cement plant, the writ petition will be affected in as much as he holds patas for certain plots within the proposed project area. He also submits that though representations have been made before the concerned authorities with regard to his grievance and around a prayer to stay the hearing on environmental clearance, which scheduled to be held on the 19th, the same has met no response, which has compelled him to approach this court by way of the instant writ application. That's why then Advocate General, in reply, has submitted that the writ petitioner, in fact, is a stranger to the issue, and a perusal of the patas which is annexed to the writ petition would clearly show that the land to which he claims to be the owner of are different and separate from the land where the project is to be, where the project has been proposed, where the cement plant has been proposed to be set up. In this connection, the AEG has also referred to the names shown in the two patas, namely pata number 600 and pata number 1462, which refers to plots of land known as Madan Rasbung, Madan Rasbung 600 and Madan Seikbu, Madan Seikbu. He submits that the writ petitioner has not even established, has not even prima facie established as to how he has come into possession of these lands. No, not even, therefore not established any case to call for any interference at this stage. The further counsel for the parties also peruse the materials that have been placed. It appears from the submissions that the grievance of the writ petitioner would center around the issuance of around the public notice, that is the public notice dated 18 November 2025, whereby a notice of public hearing has been notified, which is to take place on 19/12/2025. Attempts have been made by the Senior Counsel also to show that there has been an illegal mutation of the patas in favor of the respondent number 4, who alleges has in turn transferred the same to respondent number 5. A perusal of the public notice, however, shows that the project site is in Dice Tong Village, D-A-E-S-T Tong Village, Ejanta Hills. And there is no averment in the writ petition as how the two lands in question, over which the writ petitioner claims to be a valid patta holder, is connected. Stop. Further, next paragraph. As the matter involves the environmental clearance, stop, which has no connection with the dispute, as a dispute as stated by the writ petitioner, no interference qualified at this stage. This is the matter after vacations is for the order.
May I be permitted leave to add JHADC as my learned friend has now said?
Mr.
I am not saying.
As the
JHADC is not a
It is
party.
for you
at
to.
the close of dictation of the order, Mr. Ezra Praise be allowed to array the Joint Council necessary party. Praise allowed.
11.
Just Lordship, I have filed the additional affidavit, Your Lordship, as per the yesterday's order, Your Lordship. Now, what happened in this case, Your Lordship? Without any notice or without
Only
any.
one thing: was he allowed to shift the wine store or not?
He was allowed, Your Lordship, but the people are up against the setting up of that wine store in that particular area, Your Lordship. There was objection.
But he has an NOC.
There was a
There is
objection
NOC
from the church.
there is NOC from the
local resident, Your
How
Lordship.
far is your wine store from the church?
It is very far, Your Lordship. We have complied with all the more than 100 meters.
You know,
They have allowed.
was that provision?
There is also
119 Assam Excise Act. What's that?
there is in the judgment order dated 30/8/2020. The division bench order also have reflected, Your Lordship, where all this provision was completed. That judgment was reflected in the para. This one is there. That all this whatever the guideline it is laid down. That is I have comply, Lordship. And moreover, this it shows that they have clearly there is a that
No,
letter.
where is that?
Lordship.
See, Mr. Shulai,
Lordship.
if in accordance with the act and rules, if we allow for shifting of the wine store, before allowing shifting also there are certain requirements where you have to meet.
Lordship.
Like the NOC from the local area.
There is
So
nothing
here,
as such,
here
Your
they
Lordship.
obtain that.
There is nothing as such, Your Lordship.
There is,
They do the petition.
I have enclosed the no objection from the headman. It is there.
Where is
The
objection?
headman is the Danakri Akung. There
Where
is
is that NOC?
I have annexed
Give me
it.
the flag. Give me the
Annexed
flag.
it. This page 38, my lord.
Page 38.
Yeah, that is this is the type copy. The original. It is in Karo version. Yes. No. Yes, Lordship. This is from Nokma, Your Lordship, where it is that not only Nokma, the other members also. It is stated that I, Srimati Inila Sets Marak Dhanakri Village Akung Nokma Headman do hereby informing in written that that Srimati
See this page 40.
yes,
You should have done.
Lijita D. Sangma, daughter of
what about
late
this?
Harmingstone Sangma, resident of Sunny Hills, West Karo Hills, Meghalaya, have obtained the license.
Wait.
Lordship.
Don't rattle like that.
Lordship.
Let's see the NOC from the local Nokma headman. Where's that?
This is the Lordship which I am reading. This one.
Which one?
The 38, page 38. This is the translated copy. The original is page 35. With he has given with the in the letter fed Garo Hills Autonomous District Council Tura, office of the Akung Nokma.
Yes, see, Mr.
Lordship, kindly have
if on paper he has all compliances, then how can you?
Lordship, kindly have. Lordship, it is not we who did not allow him to operate, Your Lordship.
Okay. Oh,
Lordship, kindly see. We are not the one who stop, Your Lordship, the operation of that wine store, Your Lordship. But it is the public, Your
can the
Lordship.
church be they on morals, yes, but can they, if receive NOCs or not as per law, can they say that morality of the people.
Because we have allowed the shifting, Your Lordship.
You allowed it.
But it is the people who did not allow the petitioner to operate the wine store, Your Lordship.
This is Baptist Church.
Even then, Lordship, they should be given an opportunity. What type of complaint, whether there is any examination, whether that complaint can be considered, whether it's a genuine.
What is that rule?
That opportunity should be given to the petitioner. I have never received any copy. Even there is not even a office letter from the state respondent preventing me from operating this one, but just for telephonic conversation.
Mr. Shulai,
Lordship,
there's been a public hearing 20th March 2025 where all these people have signed. They are around how many people have signed in favor?
Lordship, out of
in favor and against
majority,
in favor they are 23 and against they are
only 23 people are in favor, 73 are against, Your Lordship.
Then why do you allow shifting before obtaining the, where's notice as per the Act, whether you issue to the local residents?
Lordship, if we go by the
Assam Excise Act.
Lordship, if we go by Rule 191.
191, yes.
Lordship.
But then where's that notice? When
Lordship, yes.
Before allowing to shift, you should have taken exercise.
I'll have to take the complete instruction, Your Lordship.
You don't need to take instruction. Yes, as per law. And if you allow the shifting, that means it's understood that all the what do you call requirements have been fulfilled.
Renewed payouts have complete till 2026, my
No, forget about your payment. It's not important. How far from the church?
Lordship, as per the complaint, there is no indication regarding the distance.
Then where's the complaint? The complaint, see, you read the complaint. On behalf of so-and-so church, we would like to express a deep concern regarding opening a wine shop. As a church committed to promoting peace, moral values, and all welfare committee. The area has educational institutions, rest places, no distance. Opening wine shop in such sensitive location will lead to an increased antisocial activity, safety concerns, women, children, negative influence on students and youth.
And then
alcohol is a negative influence.
Kindly have also the complaint of the Tura Town Church, Lordship.
That is what. It's not from the residents at all. These are from pastors only.
It's true, Your Lordship.
Then this also, see, the town church, a pastor in charge, and even the other one is pastor, what's this, Baptist church.
As I have submitted, Your Lordship, we are not the one who...
You're not the one, you just wash your hands. Rule of law, even though it is a trade which no rights can be, he cannot enforce. There's not a violation, no vested right there in a liquor trade. But even then, if a person has legitimately, it's not a question of illegal wine store,
it is a licensed wine store, Your Lordship.
Under your permission,
we have allowed him. We have allowed the shifting, Your Lordship. We have allowed. There is no denial of that fact, Your Lordship.
There's a judgment recently passed by this court. Who appeared in that matter?
Mr. Siddiqui.
No, Mr. Chari. So.
Oh, yes, not.
Lordship, kindly, if Lordship kindly have Rule 191.
We don't need to look at that rule. That rule is to be complied before you allow the permission.
Lordship, yes.
Not after you apply the rule after you've already allowed permission. Can you say that okay, fine. Okay, fine. We've given you approval. After approval is granted, then after you comply with this rule, which is a pre-approval requirement.
It appears, Lordship, that 191 rule has not been complied with. It appears, Lordship,
from the NOC is from Nokma of that area. He says there's no harm. He represents all the residents.
Let me have the complete instruction, Your Lordship.
Lordship, till the next date, I should be allowed to just open the.
Yes, then they might come and close your shop.
Lordship, we are not allowing him, Your Lordship. We have allowed him, Your Lordship. We have allowed the shifting. We are not the one, Your Lordship, who did not allow to operate, Your Lordship. It is the public, Your Lordship. It is those are a member of the church, Your Lordship. who are against the opening of the swine store, Your Lordship.
Exactly. They will always object. Yes. Take down his where's the last order?
Yes, last order I have included my in the gender. My gender.
Yes, the petitioner. The petitioner is a license holder for a retail vend of IMFL. IMFL within inverted commas OFF license. First in Janji, you shifted from Janjal now, or
Yes.
you're in Janjal now?
Now in Danakri, no more in Jinjal.
Before it is in Jengjal, Your Lordship, now to Danakri.
For its license holder for retail vend VND of IMFL or off license, which was granted on 13/9/2022. If you stop the shop, the retail van was located at Genjal, GENGJL Market, Genjal Market, West Garo Hills, and the petitioner was operating the same after paying all the due license fees as also other charges. Stop. Thereafter, it appears the petitioner, being desirous of shifting the wine store to a new location at Danagre, DNAKGRE, had approached the authorities to respond for the same after obtaining no objection from the local headman Nokoma on 23/7/2025. Stop. Thereafter, where's that affidavit? Thereafter, on completing the formalities, the respondents by order dated 29/1/2025 approved the shifting of the premise from Janjal Bazaar to Danagre opposite BSF camp in West Garo Hills. So, the grievance repression is that though valid permission had been granted by the state respondents, the said retail vend has not been allowed. Who closed you? Who didn't allow to operate?
Superintendent of Excise Tura.
The respondent number.
That is, Lordship, I'm disputing that submission, Your Lordship.
Is this a submission?
Lordship.
You dispute submission. That is not the court finding. The what? That though when it was stop functioning, you opened 25. It functioned.
Yes, I was opening
that after a relocation. However, and when the retail van was in operation,
yes,
the respondent number 3, that is Superintendent of Excise West Garo Hills from Meghalaya, has
just called the telephone.
Prohibited you?
Yes, prohibited me
from operating the retail van, from operating the said retail van. Stop. Then council submits that the action of respondent number 3 is contrary to law, in as much as it is not a case of an illegal operation, but the shifting and the operation of retail van was after due permission has been obtained from the respondent's staff, from the concerned respondent. Mr. N.D. Chulai then AG today, as on instructions, has submitted that the suspension of the operation of the retail van. Someone authority has to go. You can't just have people going. If people going, you would have put that here. Some of the suspension retail van is in view of the complaints which have been made by before the deputy commissioner or before the deputy commissioner, West Garo Hills, by the pastors of a Baptist church, by pastors of two churches who have objected, to two churches, and that on this objection, the operation of the wine store has not been allowed to. The operation has been suspended. He further submits that perhaps it is a case of the opinion of the public not having been obtained as per Rule 191 of the Meghalaya excise rules, which have since been adopted. Meghalaya excise rules. He prays that he may be allowed to obtain further instructions with regard to the location of the shop and its vicinity, and whether it's the vicinity of any church or educational institution. On hearing the counsel for the parties, it is noted that this is not a case where the petitioner is operating without any sanction of law, inasmuch as due process has since been complied, even by the this one was played has been evident process for transfer has also been allowed by the deputy commissioner, that is the respondent number 2 himself. However, it appears due to the objections of certain individuals, the matter, the petitioner's business has been affected. Though trade in liquor is not a right, but once having been issued a valid license, it is expected that the state respondents themselves will address the situation as not to cause loss or injustice to any person. In the instant case, it is noted before the suspension of the activities, participant number 3, you know, show cause nothing.
No.
The petitioner was never afforded any opportunity to even present his case, and it appears the authorities have acted on the complaints made by the certain individuals. So, in this view, the matter and the age is directed to obtain instruction regarding the vicinity, and also otherwise you can't just, without hearing, how can you just?
Our Lordship, yes, that is.
Is that to instructions also to direct the respondent number 3 to convene a meeting between the petitioner and the residents in the vicinity. Is that to direct the petitioner not 3, number 2, between the petitioner and the headman. We won't call the people within 1 week from today to understand the issue and to allow the petitioner to present his case.
Lordship, whether those stakeholders will be called, Your Lordship?
No.
Lordship, in the meantime, just allow me to open the shop only for time being. For the next
situation, then we can't have that also. You have to balance.
Actually, these individuals, they never come physically.
They won't come and buy. Why should they come?
No. They don't come and complain. Even they obstruct. They just file a complaint.
Yes, they just file a complaint. Let them call. Yes, and the deputy commissioner should take appropriate action.
Yes,
only hearing the headman and the petitioner. He has to be heard. You can't just condemn him like that.
Till the next date, I may be just allowed to operate because I'm.
It's also directed to examine the feasibility of the shop being open without causing law and order problem. Yes.
Much less, Lordship.
What has you got here? Mr. Datta will have your cricket matter now. You try to complete it by 1:15. Yes. Have you made your notes on submissions? Just make your note, otherwise you've heard the matter substantially. Since this matter is urgent.
Yesterday my learned friend had
only one or two. I'll take 5 minutes only.
Yes. Yours is only two basic points: the
appointment
window of objection and the electoral officer.
And campaigning period also.
Okay, yeah, campaigning period, yes. Yes, 5 minutes.
And I've shown that, my lord, one of the members in the candidates in the electoral list, in the voters list, is not authorized.
Yes.
If we were given a chance, we could have objected to him.
Yes.
Given a chance, we could have objected to him. Now, my lord.
Yes.
In their affidavit, they've taken some objections, my lord. First objection is that there are some uncontested candidates. They have not been arrayed as party.
Yes.
Second objection they've taken is the Union of India is a necessary party. Now, second objection they've taken the Union of India is a necessary party.
Why Union of India?
It oust me, my lord. Maybe it oust me.
no, nothing against him.
Nothing. Union of India has nothing to do with this one. And contested candidates, my submission, my lord, the final.
Yes. Okay. You should just do it. Where's the objection to the objection to affidavit? Yes.
In para 4, they've said, my lord. So some 5, 6, 7, 8 lines, my lord. That Mr. Rajiv Bara has been declared unelected, uncontested, and so and so when the list of candidates was published. Similarly, the other candidates who have been declared selected and contested, namely so and so, Chubar Marak, have not been made parties to the present proceedings. Whereas the relief asked for, if granted, would affect their rights.
Yes. Yes.
So, my lord, to all these objections, my only submission will be, my lord, that at this stage we are challenging the very appointment of the electoral officer, and they, if any right accrues to them, my lord, that will accrue only after the publication of the result. Once a winning candidate list is published by the electoral officer, my lord, then only they can say that they are necessary party, and not at this stage, my lord.
Yes.
Now, my lord, other aspect, my lord, in the writ petition, they are interchangeably using the word petitioner and petitioner's secretary, my lord. Now, the petitioner is an Ceylon Cricket Association, it has to be represented by its secretary, my lord. And the petitioner before Lordship is not Peter Savian, it is Ceylon Cricket Association, my lord, because he is only signing on behalf of Ceylon Cricket Association. Now, Peter Savian, in the present body, my lord, he is one of the nominated members. There he is not representing Ceylon Cricket Association, my lord.
So petitioner is a nominated member?
Is a nominated member.
Put that.
My lord. So he is not representing Ceylon Cricket Association in the present committee, my lord. So any action in his individual capacity as a nominated member in the present body, my lord, will not stop or will not amount to any kind of waiver on behalf of Ceylon Cricket Association, my lord.
And he doesn't represent SCA, that means?
He is not representing SCA in the present committee, my lord. Now, my lord, other objection they have taken, my lord, is with regard to the dispute resolution mechanism.
The Apex Committee.
He is a nominated member in the present Apex Committee, my lord.
Okay. Yeah, okay. Yes.
Writ petition. Writ petition.
Yes.
Now, my lord, they are referring to certain dispute resolution clauses in the memorandum, my lord. I'll just take your lordship to, there is one provision with regard to ombudsman, page 59, my lord, of the writ petition.
Yes.
Para 40 of this MCA. The ombudsman, the association will appoint an ombudsman at the annual general meeting for the purpose of providing an independent dispute resolution mechanism. The ombudsman shall be a retired judge of a high court, so appointed by the association after obtaining his or her consent and for term as determined by the association. In keeping with the dignity and stature of the office, the term of the ombudsman shall be 1 year, subject to minimum of 3 terms in office. Now, there is no clarity whether any such ombudsman really exists or not, my lord. And otherwise also, my lord, the jurisdiction or the scope of ombudsman is very limited, my lord. Grievance redressal, my lord. The type of dispute difference that form the ombudsman's ambit at the procedure for redressals are members association and franchisee disputes. It is not a members association franchisee dispute, my lord. B is detriment caused by member or administrator.
Have you taken that ground in the affidavit?
They have taken this ground.
Where is that ground? Which paragraph?
Just point out. Para 26, my lord.
(26). Yes. Okay.
And then at page 60, my lord, misconduct or breach of by others. So these the disputes we are raising, my lord, do not fall within the ambit of ombudsman's power.
Yes. Yes.
Now at page 68, my lord, there is another dispute resolution mechanism bill provided, my lord, in the code of procedure issued by the electoral officer, my lord.
Yes.
At page 68, para 10, lords will see. In case of any dispute or objection as to candidacy, disqualification, eligibility to vote, or admission or rejection of vote, the electoral officers will decide the same.
Since you're questioning electoral officer himself,
I'm questioning the very competence, the very authority of the electoral officer.
You already made a submission.
Yes, madam.
Yeah.
Now, my lord, as for representation, we submitted 2 representations, my lord. It page 190. This is the first representation of 3rd December to Deputy Commissioner, my lord.
Yes.
And page 207, my lord, let's kindly see. This is the representation to electoral officer himself, my lord, raising all these issues. Now, what Deputy Commissioner did, my lord, on our representation.
Already, what happened here?
Now, my lord, that your lordship will see it as a rejoinder, my lord.
What did he do?
Page 26 of my rejoinder, my lord.
What power does the petitioner have?
As a law and order body, my lord.
Yes.
So the 8th December, it says, my lord, with reference to the subject and to your letter under reference in a perusal of the inquiry report, because DC directed for inquiry, my lord, by a magistrate, I am to inform you that the matter is as follows. The allegation of the Ceylon Cricket Division in respect to the procedure lapses in the Meghalaya Cricket Division General Assembly are not disputed. Deputy Commissioner is not mandated as the competent authority for redressal of grievance pertaining to the conduct of elections as the Meghalaya Cricket Association. It is recommended Ceylon Cricket move the competent authority for redressal of their grievance. So, my lord, at least this shows, my lord, after an magisterial inquiry also, the lapses were.
Okay, then next, what about the other representation to the electoral officer?
My lord, there is nothing on that, my lord, till now.
Okay, anything else?
My lord, judgments I already placed. Your lordship, I can make a note of submission, my lord. I can place it by tomorrow.
Yes, you give it by today. You give it by at the end of the hearing. Yes.
Today I have not.
Yes.
Whether the subject matter in dispute before your lordship is concerning an election process, and the election process is that of Meghalaya Cricket Association, which is a registered society under the Societies Registration Act. Now, plain and simple, what I understand, my lord, barring the existence of respondent number 5 deputy commissioner, all the other authorities are private authorities as such. And it's not against, the writ petition is not filed against any state in that sense of Article 12. So my first submission is that, my lord, the writ petition in this present form is not itself maintainable.
Yes.
The second thing is that, my lord, if your lordship will kindly see who is the petitioner before your lordship. My learned friend has also now clarified that Mr. Peter MacDonald is not the petitioner. Very well. Then the petitioner becomes the Shillong Cricket Association. And in the scheme of the...
No, he submitted that he is a petitioner, Peter, not the Shillong Cricket Association.
But the writ petition is Shillong Cricket Association, well.
Then who
is represented by, is in his capacity as secretary, well.
No. It's an individual capacity just now.
Well.
It's an individual capacity.
No, well, I said petitioner is not Peter Sagan, well. The formal petitioner in the writ petition is Shillong Cricket Association, represented by its secretary, Peter Sagan.
No, it's not secretary, he is the president.
President, well, sorry.
No, it's represented by the president.
Yes.
Now, what is the status of this Shillong Cricket Association in the context of this election? Well, the election is to be held for the purpose of electing 6 members, rather 4 members, I should say, to the Apex Council body, and who will select the 12 affiliated clubs or 12 affiliated cricket associations. Now, Shillong Cricket Association is one of the affiliated associations under the MCA. The status of the Shillong Cricket Association is nothing more than that of a voter.
Yes.
It has only one status, my lord, that is of a voter. Now, a peculiar thing has arisen in this case, in the sense, my lord, here is a case where a voter is questioning the election process. It is not a case where, my lord, some candidate is coming before your lordship and asking for interference on the ground that there are A, B, C, D, X, Y, Z illegalities or irregularities. Therefore, my lord, my first and foremost submission would be whether at the instance of a voter, an election process can be interfered with. My lord, my respectful submission is that, my lord, the answer has to be in the negative. Because the rights of the Shillong Cricket Association, even if assumed to be there in any manner, my lord, as on date, my lord, it is only with regard to casting of vote.
Yes.
Barring the right to cast their vote, my lord, they have got no other right. So how do you come and complain that there is a run-off schedule given on 26th of 11/2025 or the list is published in 27th of 11/2025? How these publications of lists or the run-off schedule are going to affect any of your rights in any way? Because your right is limited to cast the vote, and the voting will be held on 9th. You have to go there, you have to cast your vote through your authorized representative. So, in the writ petition, my lord, basically none of the rights of the petitioner is affected.
Yes.
And practically, my lord, there is no cause of action, I would say, for the present petition. In the sense that Shillong Cricket Association does not have any candidate of its own as well. They fielded one candidate who withdrew the nomination on 2nd, and therefore, my lord, it's a fray where, my lord, they have no interest except for casting their vote. Now comes the prime challenge, my lord. Prime challenge is with regard to the appointment of the electoral officer. Yes. Now, in appointment of the electoral officer, my lord, in our affidavit, my lord, we have indicated that there was a agenda on 13th of November, which your lordship will kindly find at page 18 of the affidavit.
Yes.
Now, in the page 18, my lord, the name of Mr. Peter MacDonald appears at serial 7. Now he acts there as a nominated candidate, nominated member in the Apex Council.
It's 13 November, right?
13 November. And thereafter the list is published on, the schedule and the draft roll, whatever has been done, Milord, that is just in pursuance of this resolutions adopted in this meeting.
Yes.
Now, if the resolution has been taken and there was no objection taken that the election of electoral officer who was going to be appointed is not to be found as competent, Milord. In that circumstance, Milord, how can you maintain a challenge? And most surprisingly, Milord, in the entire of the writ petition, there is no relief asked against the respondent number 2. There is not a single averment that respondent number 2 is not eligible to conduct the election. Although, my lord, voluminous argument has been made on the eligibility and his authority to act as the electoral officer, your lordship will find from the pleadings in the writ petition, my lord, there is none. They say, all that they say, that respondent number 2 has been conducting the election in an unfair or improper manner, non-transparent manner. But the very fact that he does not have any authority to act as the electoral officer, my lord, that is not there in the pleading. And if your lordship will kindly see the prayers, which is at page 26. Page 26, clause C, your lordship will see, that is concerning the respondent number 2.
Yes.
Issue a writ of mandamus directing to set aside the arbitrary, illegal and malified electoral process by the electoral officer respondent number 2. Now, in support of this prayer, my lord, there is not even a whisper in the writ petition that he has been doing it without any authority of law, or he is an incompetent person to conduct the election. Secondly, your lordship will see in the rejoinder they have given a list, assuming for a moment, my lord, that the argument that the election, since I have challenged the election process as a whole, and therefore the eligibility can also be gone into question. Your lordship will kindly see the annexure 2 of their rejoinder affidavit, page 24, which was filed yesterday, my lord.
Yes.
Page 24 lists, my lord, 3 categories of persons.
No, but are these directives mandatory for your elections also?
I am adopting their version that it is mandatory.
Okay. Yes. No,
I am adopting.
We are clear on that.
Yes, I adopt their argument that this is mandatory
for you.
Yes.
Yes.
Let me proceed on that basis, my lord. It is mandatory.
Okay.
Now, even if it is held to be mandatory, my lord, then this particular page 24 indicates existence, recognition of 3 categories of persons to act as the electoral officer. Well, the argument has been made yesterday that these 3 persons, the eligibility will be determined only on the non-availability of the person who is higher in the order of hierarchy. Well, that submission, in my respectful submission, is flawed. The reason being that, my lord, an eligibility of a candidate for a particular post is not dependent on the non-availability of the pool of choice. If I say that, my lord, these are the only three, the language is very clear, my lord. Member association shall appoint an electoral officer from any of the following categories. And these are or. Every category is.
No, we observed that yesterday also.
Yes. So it cannot be said.
That's not in descending order.
Yes.
Preferential. It's not in a preferential order.
It's not on a preferential order. So going by that also, my lord, the argument that has been advanced that the electoral officer lacks jurisdiction to conduct the election, my lord, that is flawed in my respectful submission. The second point that I will argue is, my lord, the second point is that, my lord, they have said that there is a list of persons given in the rejoinder, and the list of persons are the past electoral officers available in the state, and therefore the argument was that first of all the MCA ought to have explored the possibility of drawing these persons, and only in the event of non-availability of these persons, they could have gone to the neighboring state. Well, that argument will also not hold good. for the simple reason that, my lord, the requirement that has been spelled out in page 24 does not say so. It does not say that first of all I'll have to explore the possibility of getting the pool of choice in my state and thereafter only I can go outside. Secondly, my lord, the persons on factual aspect, my lord, the persons who have been named in the list, my lord, they are all above the age of 80 now. Out of the page 22, your lordship will find at least 8 persons have been indicated, 10 persons have been indicated there. And I just took factual instruction, my lord. The first 3 persons appearing on the last, left hand side column, my lord, they have left the world. And my lord, that is also noticeable from the period, my lord, during which they worked. So they have left the world, and the persons named in the right hand column, my lord, they are all above 80 years of age.
No, that's not true. Right hand column, all 80 years of age.
My lord, right hand column, my lord, I can name just Mr. P.J. Bazeli, he is 86. A.K. Srivastav, he is 85.
I do not think so.
Then, my lord, that is the factual instruction.
I think absolutely wrong. My brother is there now, number 4.
Mr. Naik also is.
My lord, I am yet to come to number 4, my lord.
Number 4 is.
I am yet to come to number 4, my lord. I was just referring to number 2, A.K. Srivastav.
That is a totally. Mr. A.K. Srivastav also is not 80. Sorry.
Maybe, my lord. Since there is just a factual instruction, my lord, there is nothing on record on that aspect, my lord.
Then you withdraw the submission.
Yes, I withdraw, my lord. But the 3 persons on the left hand side, my lord, I am told that they have left.
Fine, that is okay. They're out of contention. But if Mr. Naik was by your MCA itself.
Yes.
Engaged in the last election.
Yes, Naik was there in the last election. He was there in the last election. So, but then the submission made that first of all I'll have to explore the availability of the pool here, and fine. Only on non-availability, my lord, my choice.
Who gave the instruction that over 80? Will let that person come here?
My lord, that is. Huh? No, age of retirement. It is not the age of retirement.
This is the age when they held the office of CEO.
It is the time during which they held the office.
Yes.
So, my lord, that is the thing. Coming to the next point, my lord, the array of parties. My learned friend has also indicated to your lordship that I have taken objection with regard to the array of parties. Well, the first objection is with regard to the BCCI. Yes, I'm sorry, my lord, Union of India. All of the citations that my learned friend has placed before your lordship's consideration, my lord, in all of the cases your lordship will find eventually the Union of India was party, because the state federations were also party in the, the national sports federations were also party in that case. Now here, my lord, BCCI is a national level sports federation, and therefore, my lord, the Union of India becomes a necessary party in the case. I've got nothing whether Mr. Mozika presents the case or somebody else. My lord, he said that it is to oust him, my lord. It's nothing. There is nothing like that. But I make this submission because of the fact that even if your lordship will look at the citations that my learned friend has produced, my lord, in all of the cases, my lord, Union of India and the national level sports federations were party. So that is one. Second is that
you objected. You made a submission that non-joinder obviously parties. Okay.
Yes. The second one is that, my lord, the elected candidates. Now the voter is coming before your lordship saying that the run-off schedule of 26th 11.
Come to that. That's the main point.
Yes.
Run-off schedule.
Yes.
Whether it calls for a free and level playing field.
Now, my lord, my question to myself. I ask a question to myself, my lord. Who will be eligible in law to ask that issue, raise that issue? Is it the candidate or the voter? Here is a case. Here is a case, my lord.
Yes, the thing is that, but we're looking at the circumstances of the case. Now he was a candidate who has since withdrawn his nomination, has come and questioned it now.
Yes.
Yes.
Now, therefore, my lord, my submission is that basically it's a writ petition, my lord, where a candidate disguised as the association has come before your lordship, because the candidate cannot come directly, since he is not in the frame, my lord, he cannot come directly. So therefore, in the guise of the association, my lord, he has approached this honorable court. Now that becomes a motivated exercise, because you are a voter. If I take you as an association simpliciter, you are simply a voter. What business you have got to say? If the window of objection is large or it is restricted, none of your rights are affected thereby. You are to only go there and cast your vote. You are not also in a position to question the authority of the election officer, because you have got no business with that. Yes, a candidate may come and say that the window is restricted or the choice of representative is wrong, because if the
file representation before or after you withdraw your nomination?
After he withdrew his nomination. I don't say he, my lord, the president of the association. Now, this is also very schematic manner, my lord, it has been done. If your lordship will kindly see the resolution that they adopted for filing this case, which appears at page 29. Page 29, your lordship will see the date of the meeting is on December 4th.
Yes.
The president withdraws the nomination on December 2nd. Then a meeting is convened on 4th and a resolution is drawn that for the purpose of challenging the process of the election, so and so persons will be authorized. And the name of the candidate, my lord, president, he figures at the serial first. Therefore, my lord, it is entirely a motivated petition filed only to stall the process of election, because what he could not get directly, my lord, in the contest, he is trying to achieve that in an indirect manner.
No, but you see, one thing now, Mr. Lata, this is of the whatever the list here. The thing is, with regard to credit administration, now this whether it must maintainable or not has been gone to at length with the BCCI matter.
Now, I'll read one paragraph.
That comes, and then how they just this what is administrators, these council administrators, whatever were put in place, and I think Justice Loda also was.
Yes.
I mean, he had generated the report as how to be run. Now, this also flows from there only, because guidelines have been put in place, and your association and your MOA, whatever has to be crafted along the lines of the recommendations made by the Supreme Court
or the BCCI.
Or the BCCI. So now we will not look at the question of maintainability, because it is a it's like
my lord, here maintainability, I am making a submission
now
on.
Your maintainability is only limited to the locus of the writ petitioner.
That is one.
That's the only thing.
That is one. The other thing is this, my lord. Other thing, why I say maintainability, that is because, my lord, assuming for a moment that since BCCI case, Supreme Court has said that it's a state actor. So now to demonstrate that MCA is a state actor per category of BCCI, my lord, that requires some pleading. I stand up before your lordship today only to answer the charges or I mean the contentions that have been advanced in the writ proceeding. There is not a single statement in the writ petition made that just as the BCCI in the national level, my lord, MCA is also a state actor having the trappings of the state under Article 12, and that's why the writ petition is made. Well, in BCCI case also, my lord, the Supreme Court has sounded a particular paragraph. Yesterday, my lord, I was just going through the compilation that my learned friend has placed before your lordship. If your lordship will kindly turn to the page 226.
It will next judgment also.
Page 220, similar. Yesterday he shared a compilation with us, Miller, which he has also placed before your lordship. Page 226 in that compilation.
Yes.
Paragraph 264.
Yes.
We clarify that this judgment, Miller, that is the Z Telefilms case. We clarify that this judgment is rendered on the facts of this case. It does not lay down a law that all national sports federations would be state. Amongst other federations, one of the important factors which has been taken note of in rendering the decision is the fact that the game of cricket has a special place in India. Now, thereafter, my lord, in 2-3 lines, my lord, why BCCI is to be taken. Now, if your lordship will kindly come down to paragraph 266.
Yes.
Furthermore, only because a corporation or a society is a state, the same would not necessarily mean that all of its actions should be subject to judicial review. The court's jurisdiction in such matter is limited. Now, you are challenging the electoral process of a registered society. You are also a registered society. You are bringing it within the purview of the writ jurisdiction where, my lord, umpteen number of times it has been laid down that 226 jurisdiction will be very loath. Because electoral process is a democratic process, my lord, that ordinarily will not be interfered with in the exercise of this jurisdiction. Now, all the judgments in the compilation which have been placed, my lord, right from serial number 1 to, except serial number 1, 2, 3, 4, 5, these are all interim orders. These are all interim orders in the sense that some complaint was made somewhere and therefore, my lord, it was to be redressed in that manner. But that does not lay down the proposition that in election matter of a cricket association or a sports association, my lord, the jurisdiction can be exercised. And so much so, because if your lordship will kindly see the first judgment also, the Amin Pathan, paragraph 15, my lord, it has been referred by my learned friend, paragraph 15 at page 6.
Yes.
I'll just emphasize on the last sentence of that paragraph 15, my lord.
Yes.
Overall, the courts must, as your lordship got it, page 6.
Yes.
Just above paragraph 16. Yes. Overall, the courts must balance the need to preserve the integrity of the election process with the ability to correct any serious irregularities and illegalities. I'll put emphasis on this. The illegalities and irregularities have to be serious and must have a bearing on
submissions that is not serious.
Well, it must have a bearing on the right of the, it has to be just from the right of the perspective of the right of the petitioner. What is the right of the petitioner that he is espousing before your lordship?
Okay.
The seriousness of the allegation or the seriousness of the irregularities, my lord, that have to be tested from the perspective of the right of the petitioner. And not only that, my lord, the next words, illegalities that may materially affect the result of the election.
Right.
So what is the challenge to the, where is the assertion in the petition that if this election officer is not, if this election officer is allowed to function, or if this schedule is allowed to remain, it will materially affect the result of the election? Well, this submission can come only from a candidate, not from a voter.
Yes.
Because a voter does not have any right, save except sending his vote, casting his vote.
That, yes.
Now, therefore, my next submission will be on the electoral roll. Well, the draft electoral roll and the final electoral roll.
That is what the court wants to know. Also.
Yes, that has been.
Why the draft electoral roll only showed the name of the association?
Yes. Well, who are the members? Draft electoral roll should contain the name of the members of the association. Now here, no, just a minute. Now here, the members are the associations. If your lordship will kindly see the definition of the member in page 39, it says about two kinds of member, individual member and affiliate member. Page 39, clause I and J.
Yes.
Individual member shall mean life member or former international player member. J. Affiliated member shall mean district associations directly affiliated to MCA institution under Rule C. Yes. So we are the district associations. Here is a case where the members are all district associations. So naturally, my lord, the page 38 would contain the name of the members.
Then why do you publish a second list then?
No, because if you
say it's not important that only the that association votes, then why does necessity of publishing second list?
I'm coming to that, my lord. I have published the draft roll. Now,
draft roll is a name of the associations only.
Yes.
And the final rule contains the name.
I'm just explaining it, my lord. Yes. The object of filing the draft roll is that some association may come and say that this association has incurred some debility and therefore they cannot vote. So that is the purpose of giving the draft roll. And ultimately the final rule comes. Now question comes that why the name of the representatives is indicated.
Has been given in that.
Yes.
Yes.
Now this association is a body of persons. The role that these associations have is to cast their vote in the process.
So
naturally,
when was the name submitted from each association that this will be representatives who will vote?
Naturally, my lord,
when was it given? Before the first voters list or after, in between the first voters and second voters list?
No.
When was it given?
No, my lord, my submission is that, my lord, the petitioner association has been complaining about it. My lord, if
will not be okay. Leave aside. Just for a time being. Just just assume that he has enough locus to challenge it.
Yes.
Now the only thing now we have come to the very important part of this case is the schedule given by whoever electoral officer, whatever. Now whether it is reasonable. Is it reasonable? Is it justified to have such schedule and your electoral roll first electoral roll is only associations.
Yes.
Now the time for objections, right? Then now you produce a second electoral roll on the third after the time of objection is over.
Yes.
Correct.
Yes.
And now the names of the persons come there, and they have raised the contention that normally the only president secretary.
Yes, my lord, that I am explaining.
Now you put another treasurer. So now whether it allows, your constitution allows such kind of,
Well, yes, I am.
So the thing is that what we are on, Mr. Datta, you must try to understand, is trying to see whether the entire electoral process, the integrity of the electoral process is there at all, whether, notwithstanding any other objections, whether the way the schedule has been put, whether the grievances set up, because we get a cold observe, even to don't grant any relief.
Yes.
We should put your entire election under a cloud.
Yes. Now.
So that's the only thing of how we have to explain this to the court, because we want to understand as to how we have arrived at this kind of mechanism,
Yes.
whereby when the voters list draft is published, you publish the name of associations, and when the final list comes out, you give the name of the person.
Yes. Now
to avoid any influence.
Yes, that is one of the reasons. That is one of the reasons, because your lordship is bang on the point, my lord. I am grateful to your lordship, my lord. That is the basic reason. The reason is that, my lord, the club has to, I'm sorry, my lord, the association has to field candidates. Now, associations are the electoral college. Now, the candidates who are in frame, my lord, they have to launch their campaign only in the associations. Associations will then decide amongst themselves as to who will be the candidate for whom they will vote.
Oh, but you said the president secretary will be the candidate.
No, my lord, that is a wrong projection given to your lordship. Because if your lordship will kindly come to that particular page 55, my lord, that's a wrong projection, I would say. Page 55, your lordship will kindly see clause 32, and he has referred to page 56, clause 3.
Clause page 55.
55.
Yes.
Representation in annual general meeting and special general meeting and voting. This voting is related to the voting that will take place in annual general meeting and special general meeting. It has got nothing to do with the election of the association, of the apex body.
So I'll just to the other part, yes. We want to show.
Lordship?
Now you say that 32.3 won't apply.
32.3 will not come here. 32.3 is applicable only in cases where it is the meeting of the annual general meeting and special general meeting, and the voting therein is related. The petitioner is mixing two things, my lord, together to project a case that there is violation. It speaks of annual general meeting. Now, since the, my lord, electoral college is the associations, my lord, they will have to cast their vote through some representative.
No way you show that the other members can vote also.
Well, that is the interesting point, my lord. The rules do not, the memorandum of association do not say that who can be the representative to cast their vote. Except for this, my lord, in respect of annual general meeting, in the election whether a particular member will be authorized to cast their vote, my lord, the memorandum of association is silent.
Okay.
There is also no challenge in the writ petition that the memorandum of association is not in conformity with the BCCI constitution. And therefore, memorandum of association is not applicable, or the procedure laid down therein is not applicable. There is also no challenge on that point. I can understand, my lord, if the schedule, yes, very well, the schedule appears to be somewhat restrictive, that 26th the list is passed, within 27th you have to file your objection, it appears to be restrictive. Now, if you say that this is in derogation of some law or some guideline or some laid down procedure, you must demonstrate before the court which is the laid down procedure in deviation of which the list has been published.
Yes.
There is no assertion in the writ petition that this schedule has been drawn in deviation or in derogation of this law. So therefore, my lord, it is too late in the day to raise a complaint now. And 26th the list was published. 19th of November the list was published. Why didn't you raise any objection at that point of time?
Yes. No, that's noted. With regard to non-taking objection, that's noted.
Now I will also explain the draft list and the reason for publishing the list of the names, my lord. Now, page 69, your lordship will kindly see. Sorry, before 69, my lord, I will take your lordship to page 68. My lord, page 68 has been focused, particularly the clause 2. If election is required to be held for the post of 6 members of Apex Council, period between so and so and so and so would be designated as campaign period to enable prospective candidate to seek support of members of MCA. It does not speak of the representative of the MCA. Because
this is a general thing, member is.
Well, it has to be, my lord, because the members are the associations. Members are not the representatives. Members are not the individuals. In their favor on the voting day, the campaign period.
Just continue next argument.
The my lord, just 2 lines, my lord, here. The campaign period may be used for the candidate for campaigning. However, during the campaign period, candidates will not use unfair means, including bribery or appeal or to use or of religious symbols, nor distribute gifts of various kinds, etc., my lord. The objective is that so that you do not influence the persons. Now, here also, the time limit given is from 2nd to 8th. What is the earth-shattering difficulty if the list is published on 3rd? Because you say that I do not know before whom I shall complain or I shall campaign. I take it as a valid argument, my lord.
Yes.
You will campaign only because of the electorate, not before the representative, because the representative will only communicate the will of the association.
How do you say that? Well, when he goes there, secret ballot, he can vote whenever he wants.
No, my lord.
Even if there's a whips issued in parliament or whips issued in assembly, also you have cross voting.
No,
how do you explain it?
Yes,
you can't advance an argument to say that once the will of the house or the whip issues a whip, I mean, for voting in favor of any motion.
My lord, we are aware that there are instances of cross voting. There can, I mean, the cross votings can take place. But my lord, we do not see the process from the perspective of the fact that there can be cross voting. Lord, cross voting happens everywhere, my lord. But the basic idea of basic idea of creating the draft electoral roll or the final electoral roll is to notify the people that who are the pool of the electors. Now, these pool of electors will have their choice, and that choice will be exercised through a representative. Now, if the representative, according to you, is not competent, you must demonstrate. You must demonstrate. And when will you demonstrate it? Naturally, before the electoral officer? I could have understood, my lord, very well that electoral officers' authorization or the exercise of duty is seriously challenged in the petition. Well, in the writ petition, there is not even a single whisper that he is incompetent to hold it or he is not authorized in law to hold it. So how do you overcome the clause 7, which is at page 67, that the disputes and objections are to be raised before him?
Yes, so, that's a valid point, but only thing is that with the schedule, that's the thing that's troubling the court.
No.
Very frankly speaking.
Yes, my lord, I can understand, my lord.
Even integrity of elections is not a question of anything very mandatory. But it's a question of the general doctrine of principle governing all types of elections.
Yes. It has to be
fair play in action.
Yes. It has
fair
to be.
Fair play in action has to be transparent, has to be seen on the schedule itself.
Yes.
That allow any person who's might have the option that that should be there. But to make it so restrictive, that it becomes difficult, to what do you call it? For any other decision to be taken, maybe by the election officer himself also, when a petition is put.
Now this I have shown to your lordship, this schedule and everything, it is just an exact replica of what surfaced in the resolution of 13th November 2025. Particularly the president of the petitioner association. Even if I take this argument that the member of the president acted, the president acted in the capacity of a nominated member.
That we've noted. So we have noted that he was a member of the apex body, nominated otherwise. We have noted also that when the electoral officer was appointed, he ratified the decision made by the earlier meeting. And so, although he's part and parcel of the entire, I think the only thing is that now that concerns the court is notwithstanding even his case, but this kind of schedule is,
Now that my submission is that, my lord, even if that is to be viewed as in deviation of some procedure, my lord, that procedure must be laid before your lordships. So, not only that, my lord, the consequence of this deviation.
You see, Mr. Datta, is not to invalidate elections. It's just to iron out the difficulties.
Exactly.
Or inconsistencies. That's all. That's the duty of the court. Also, see that there's been brought notice, divorce, everything else, whether the inconsistencies can be ironed out. Ensure that a free and fair election takes place.
Now I could have understood the argument from the other side, my lord, on this aspect of the matter. Had there been a case that because of the schedule, my lord, there was some difficulty faced by them, and they expressed their difficulty before any of the authorities prescribed. They were silent. They were all okay with it. They awake up only when they realized that their chance of winning the, their chance of that is there.
You don't need to. You don't need to spell that out.
Yes. Now, my lord, as your lordship is saying that this restricted thing, the 20 just 1 day time.
Yes.
That must have a bearing on the materially affecting the result of election.
Yes.
Because election process, my lord, I need not elaborate before your lordship, my lord, the grounds are very limited. The corrupt practice, acceptance, improper acceptance or rejection of candidature, and violation of some procedures and guidelines. Now, which are the procedures and guidelines violated in the case? The mere violation simpliciter will not do. The violation must entail a result which will materially affect the result of the election. That is absolutely missing in the case. And this, therefore, my lord, this is quite premature. Yes, today the election is held. The candidate is returned.
Where is the provision of challenging the result of election? Is it there in the MOA?
My lord, I say that other day also I said, my lord, I say that this aspect can be gone into only before the ombudsman. And even if he says that the ombudsman will not be competent, my lord, civil courts are there. Because ultimately tomorrow, if the election is held, the result is declared, you have your chance to say that, look, this person had cast his vote. According to me, this was the ineligible vote which the returning officer has allowed. Then it becomes a case of materially changing the result of the election. Merely because you are coming at a stage, my lord, when the voting is yet to take place, and you are complaining that these are the persons, my lord, at least one, if he is that too on a, my lord, on a, improper appreciation of the provision of the MOA, you say that he is an ineligible person, and if he votes, then, my lord, it will have some effect. My lord, you will have to demonstrate that if this person votes, well, it can also happen that the election officer may disallow.
Okay, coming back to the other submission, that not with, the thing is, the MOA does not prescribe as who will represent each association. Correct?
Yes.
So, according to your submission, is that anybody can be.
Anybody.
It decided within the association itself, like Mr. A will go and represent association.
Yes.
That's your submission.
Yes.
Okay. And in the past instances, when elections were held,
the same process was followed.
Anybody could go and vote.
Yes. Even I have brought on record, my lord, on the.
Have you cited any instance in early elections where,
my lord,
a similar schedule has been adopted? If you're going to go by, since there's no,
if your lordship will kindly
facts or rules that govern the schedule, like whether by your practice itself, whether you've deviated from your practice with regard to who will be the voters, representatives, or the schedule, yes.
If your lordship will kindly have my affidavit in opposition, my lord, there I have given the schedule of the last election. Yes. Same. I have given the schedule at page 20. Page 22.
I'm not challenging the schedule, my lord. I'm challenging the implementation of schedule, my lord. I'm not agree with that the 1 day was given or 3 days was given. I have not challenged that anywhere, my lord. I don't believe any
Well,
submission
kindly
on
see
that.
page 22 of my reply affidavit.
Yes.
It is the same schedule, my lord, which was there and which has been followed. Page 22 of my
I'm challenging, my lord, that the voters list published on 27th, which is the due date, my lord. The list is not correct. I'm not saying that 27th is a correct date or not correct date, my lord.
Now page 23, clause A, 3 clause A, your lordship will see.
No, what this court wants to know is whether in the early schedule also, when this release of the draft electoral roll, was it only the names of the associations at that point of time?
Yes,
That's what this court wants to know.
Yes. Well, Lord, if necessary, Lord.
Now the names,
now
that's not been revealed here.
No, Lord, that is not revealed from this, because this is the schedule only.
No schedule, but from the conduct of early elections. Now, whether when you release your draft electoral roll, that's one point that's troubling this court, if I must say very frankly, is that when the draft electoral, did it disclose the names or only name of association as is done now?
Well, in that, well, in that aspect, perhaps I'll have to take some instruction. But if your lordship will kindly see page 69, page 69 throws enough light on this. I would say
from the
page 69 of the read petition.
Yes.
Page 69, your lordship will kindly see clause 3.
Yes.
Each candidate may present to the electoral college his or her plans and views for the post in the form of written document, whatever he means whatever the means used to distribute it. So he has to project his case before the electoral college, a candidate. Now the campaign process is within the electoral college. The electoral college.
We're concerned with the list. That's the only thing that's troubling. Suppose suppose you file nomination. A party doesn't file with nomination. It's a candidate.
Yes.
Yes. As simple as that. These can be taken to be like mini parties, and they're going to put up their own candidate for whatever post. So that's the only thing. So whether the candidate is eligible or not, or he can be disqualified.
Well, I can.
Objections will come on that matter. Well, you can't disqualify an association.
Yes.
Yes.
You cannot disqualify.
Yes. And now, you can't disqualify an association. Where's the point of being objections to an association being one of the voting entities? That's all.
No. Otherwise, if it can be looked at
I don't feel iron it out. Will you reframe the schedule?
No, the question will boil down to the point, my lord, whether this schedule has affected any of his rights, any of the petitioner's rights. The lordship will. I am not remembering Mr. Peter MacDonald for even a moment. I am just concentrating my argument assuming that Shillong Cricket Association is before your lordship. Now, what right of Shillong Cricket Association has been violated by this schedule? Their right is one and simple: to cast their vote on 9th. They know the candidates who are there in the fray. They have decided amongst themselves that for whom they will vote. Which right of theirs is affected if the schedule is in existence?
The names of the persons who will vote.
No, the names of the persons are of the respective associations.
See, if it's held that as per the MOA or your rules that principal and secretary, then. But then if you say any member, that you say there's nothing that governs that, so they're free to appoint a member. That makes it all the more important that the voters list is issued, showing who will represent which association.
Yes, that is done on 3rd.
And whether he's eligible or not.
Now, if your lordship, they have also enclosed a list. That list is enclosed at page 188. If your lordship will see their list, my lord. Yes. List of contesting candidates.
One second.
This is a list of candidates.
Yes, yes.
Huh? Yes. So contempt. Yes, 188. Yes.
Well, 188, my lord. That is the list of the contesting candidates, which is drawn after the withdrawal of the nomination by respective associations. Now, from these, my lord, they know who are the contesting candidates. They know in favor of whom they should vote or they should abstain from voting. What more the cricket association will do? Well, I am an elector in my constituency. I have no business to know who is the other candidate who will be there to vote for some party or some candidate. It is the candidate, my lord, who can complain. A candidate may come to your lordship complaining that, look, this is an ineligible voter and he has been included in the electoral list.
Announcement of list of validly nominated candidates was fixed on 1st December, correct?
Yes.
And this, where's the list? 1st December list?
That is 188, page 188.
Of the 1st December.
No, 1st December list
177.
Where is it?
This is 3rd December. 177.
I want that 1st December list. You see, the thing is that announcement of list of validly nominated candidates for 1st December 2025, 6 p.m. Where's that? That's seal number 8. Where's that list?
No. Validly nominated.
If the schedule is to be followed, now where's announcement of validly nominated candidates? Where's that? 1st December document. Was it never published?
There is nothing on 1st December.
Then you will not adhere to your own schedule.
No. Malad, I'm just showing it. Your lordship is asking me on the reference of the schedule. That schedule says that 1st of December I should publish a list of
validly
nominated candidates. Whether that was done or not.
Yes.
That is page 188, my lord. That is on 2nd December.
No. This is a list of
candidates.
Because 2nd December is for withdrawal.
No, that your lordship will find in the annexure A9 collectively, 178. Annexure A 178 contains the list of candidates, my lord, the validly nominated candidates. These are on 1st of December. All the candidates, for all of the candidates, my lord, each separate lists have been.
They have not adhered to this timeline also, my lord.
No, that you are now saying that is not your case in the writ petition. You are now saying that, but your own annexure shows otherwise. Let the annexure A9 series, your lordship will see.
Yes. More civilized.
This is 178, my lord. Up from 178 to 187, my lord. This is the list of the candidates, my lord, who are declared validly nominated on 1st of December. Then the withdrawal process came, and 188 is the list drawn on 2nd of December. Only thing is that, my lord, I can understand that the list which was published on 3rd of December indicating the name of the voter and the representative. Voter or the representative.
Yes.
Well, that voter and representative, my lord, this, even if, my lord, I assume for a moment that that is in deviation of some procedure, my lord, that deviation must be pleaded and established before the court. From the point of fairness also, my lord, if I want to address that point, my lord, this deviation must have a bearing on the result of the election. And unless the result of the election is in challenge, my lord, well, it will be a futile exercise to go into in that aspect of the matter. Tomorrow, my lord, it can come that these candidates, my lord, as my learned friend has indicated, that some treasurer has been nominated and therefore he will be ineligible. If tomorrow, my lord, the vote of that particular person is counted, then there can be a case set up by a candidate. It may also so happen that the electoral officer will disallow this vote.
So this is 78 A9 series. You submit is the list of the.
This is the list of the validly nominated candidates, my lord. And practically, my lord, these are the persons only. And looking at this list, my lord, he withdrew. This also contains his name. This list also contains his name. If your lordship will kindly see the page
182.
182. Instead of a list, my lord, the several sheets have been drawn.
These are notice of nomination, madam. This is not even list.
No, but this to your knowledge. So it will qualify as a list of nominated members of the.
Now, what I'm saying that their schedule says that list of valid candidates will be published on 1st December. Right? They publish it on 2nd December, not on 1st December.
But that's what we're saying. Where the schedule, so the time, the window for objections and all is a bit. What are we to do then?
No. Therefore, my lord,
conclude before lunch.
No, my lord, I'll conclude. I don't have much thing to say, my lord, except for
5 minutes now to rebut.
Well, he'll have his chance, my lord, after I complete.
5 minutes.
Yes. Only thing is that, my lord, he is saying that the restriction. Now, this restriction in the schedule, my lord, that restriction, he has not shown any prejudice caused to him. I mean the association. Because of this restrictive schedule, my lord, some prejudice has been caused to the association, my lord. That has not been demonstrated before your lordship. My lord, they are coming in.
So you are going on technical grounds that if he has not pleaded any injury, the court should not address it.
My lord, I cannot answer. My lord, my handicap is that
address it by looking at the materials that are placed.
My lord, my handicap is that, my lord, if he does not plead, I cannot answer that.
Okay.
I cannot answer that. That is my handicap. I do not say that my lord, the court will be powerless to do it. Yes. I cannot, say that. But I cannot answer that. Secondly, my lord, my submission is that the association is invoking the writ jurisdiction of this honorable court. It is not for all wrongs that to be remedied by the writ jurisdiction. The wrong must result or translate into some prejudice caused to him or some prejudice caused to his rights. Then only, my lord, your lordship will exercise the jurisdiction. Now, coming to the judgments that have been cited, my lord. In the list of judgments, my lord, 7 except the case of Amin Pathan, 2, 3, 4, 5, the other 5, these are all interim orders. In Amin Pathan also, my lord, it was a case where the High Court had noticed that there was an alternative dispute redressal mechanism in place, and all that the High Court had done, relegated the parties to the alternative dispute redressal mechanism, and the result of the election was to be abide by that. If your lordship will kindly turn to paragraph 18 of the judgment, my lord, I make this submission on the reading of this.
Yes. Para 18.
Para 18. Para 15 your lordship has seen. Para 18.
Also, we're not clear about the alternative dispute, the mechanism in your MOA also. That's not clear.
My lord,
see, that is...
My lord, even if it is not appropriate, my lord, my submission will be that it is not the
party. Bang on a door that won't open for him. It is like that. Suppose he's not going to, if he doesn't anticipate or get, if you can, because he can easily be shut out by saying that the MOA does not, the ombudsman does not, it's not provided anywhere that he will attend to such complaints.
My lord, your lordship has noticed, ombudsman also has within his ambit
inherent powers
to decide the disputes between the member association.
Yes, now section para 18 you say.
Para 18. Thus, in view of the aforesaid observation and ratio laid down by the Honorable Supreme Court as well as this court in the cases referred to supra, I am not inclined to interfere in the election process of executive body of so-and-so in pursuance of election notice dated so-and-so. As election process has already started, due to currency of interim order, the election schedule has already expired and therefore the respondents are directed to fix fresh schedule and date for the election. The election process shall be continued from the stage when interim order dated 3/4/2025. However, since the appeal under section 35 of the Act is still pending before the appellate authority, final result of the election would be subject to the outcome of the appeal. That was my submission even on the first day, my lord.
Yes.
Meaning thereby, till final decision of the appeal, final result of the election may not be declared. Needless to observe here that all the grounds pleadings raised by the counsel for the petitioner in writ petitions shall be considered by the appellate authority while deciding the appeal, as these factual aspects cannot be addressed in the writ jurisdiction. Now, the next judgment...
We are alive to that, Mr. Datta.
Yes, no, I'm just... My lord, he has cited certain decisions, my lord. I am just trying to distinguish that whether these are applicable in the case or not. Now, the next line of decisions which he has submitted, that these are all pertaining to dispute between BCCI and Cricket Association of Bihar. And all that I can find out from the reading of the orders, my lord. These are only interim orders, orders on the interim applications, my lord, where Bihar Cricket Association wanted leave of the Honorable Supreme Court to draw their constitution in line with the constitution of the BCCI. Just for a reference, my lord, if your lordship will kindly see page 49 of this compilation. Page 49, paragraph 11. The application has been moved by the Bihar Cricket Association seeking approval of its draft constitution to bring it in conformity with the constitution of the BCCI as approved by the court. All these orders show are endeavors by the Bihar Cricket Association to draw their constitution in line with that of the BCCI. How does it have any bearing on this case, my lord? That is beyond my understanding, because the constitution of the MCA is not under challenge. There is no challenge that the constitution of the MCA is not in line with the constitution of the BCCI. And one more thing I missed out, your lordship had asked me about the past practice. In the affidavit I said, rejoinder affidavit, my lord, the appointment of the election officer as well as the other things, my lord, approval was sought at that point of time, because the 2018 judgment came. 2019 the things were at the very nascent stage, the formative stage, so rules were not in place, so we had to seek approval of the the approval committee, and thereafter the emails have been enclosed here. The approval committee permitted us to do this, so we went ahead. In fact, the state election officer, as your lordship has also noticed, Mr. Nayak was also there. Now, to raise a complaint now that I cannot do this, you must show that my actions are in deviation of certain guidelines, certain laid down norms, or certain provisions of my constitution. That is strikingly missing in the case. Therefore, my respectful submission will be, this writ petition does not deserve any consideration of your lordships. Your lordship has postponed the election till 19th. Your lordship may pass appropriate orders. The election will be held, result will be declared, and if they are agreed by the decision of the election, So they have their remedy before the appropriate forum.
Yes.
And the other day I said, Milord, today also I am saying on instruction, Milord, the ombudsman there is an ombudsman under the Justice retired Olok Chakraborty.
Of the MCA?
Yes.
You produce notification.
Notification dite parbe to? Huh? But if it is possible, if I can submit it by tomorrow through somebody. Well, that is my instruction. I am. That day also I said.
That was never brought to the attention of this court.
No, my lord.
You just.
Yes, I said that, but
he has not. I mean, nothing is brought.
Yes.
Physically.
But my submission will still be. At least he should make an endeavor before the ombudsman.
Of course.
Move him first. Move the electoral officer first. And I have seen the affidavit filed by the electoral officer, my lord. He has denied having received any representation which my learned friend has referred to.
Oh, yeah, only submissions to make. Sorry, you are appearing for the ombudsman or for the yes.
I was the chief electoral officer of Assam from the year 2007 to 11. I retired as the principal secretary of the government of Assam in 2019.
Yes.
I have an impeccable record, my lord.
No, we're not questioning your integrity. We're questioning whether you are the right officer since you belong neighboring state when they're available.
For any removal or not there is any pleadings to that effect in a repetition. And if my lord may kindly peruse.
Your name, sorry?
I am S. Khan, my lord.
Yes, oh yes, S. Khan. Yes.
If my lord may kindly peruse the Representation of People's Act, my lord, 1951.
Yes.
I am the state head of the Election Commission of India because as per rule section 20 of the Representation of People's Act 1951.
Yes.
General duties of a chief electoral officer.
Yes, we are aware of that, yes.
So I conduct, when I was the head of the chief electoral officer of the state of Assam, I conducted the assembly elections and the parliamentary elections, my lord. So the duty was pretty important, my lord. So it is not that I should not have been allowed, but my lord, there is no averments to that effect, my lord.
No one's questioning your integrity or your qualifications. Only whether you're the right person, since it provides that the CEO of the state unavailability, then that is only yes. Let him reply.
A short reply, my lord. But one submission is made that an elector cannot challenge the vote, my lord. If you take Representation of People Act as the umbrella law, my lord, section 81 says, my lord, who can challenge the elections? Yes. It says, my lord, an election petition calling in question any election may be presented on one or more of the grounds specified in so and so by any candidate at such election or by an elector. So, my lord, to say, my lord, the Ceylon Cricket Association only is an elector, he has no right to challenge the election, my lord. That is an absolutely
challenging in a writ proceeding.
Please.
Elector challenging an election process in writ proceeding.
Submission is let him make submissions. We will consider it.
So, my lord, this submission is absolutely without any merit, my lord. Now, secondly, my lord, they are saying that they can nominate anyone, my lord. My lord, kindly come to page 53, my lord, of the writ petition, my lord. Rule 25, my lord.
Yes.
It says, my lord, annual general meeting shall be held, clause A, my lord. Clause B is important, my lord.
Yes.
Annual general meeting shall transact the following business. Confirm the proceedings. I am referring to clause 4, my lord. Elect the office bearers, the other members of the apex council in the years the elections are due. So, annual general meeting will elect, my lord. And who are to be present in the annual general meeting, my lord? Rule 32, my lord.
Yes.
Rule 32, kindly see, my lord, page 55.
25, yes.
Representation.
32.3.
So 32 talks about the representation, my lord, 32.3. So, my lord, in AGM there cannot be two teams, my lord. One for the purpose of election and one for the purpose of AGM, my lord. There will be only one team, one representation by every cricket association. They will participate in the meeting in other agenda as well as there will be the people casting the vote, my lord.
Yes.
So to say, my lord, they can nominate anyone, my lord. Not even treasurer. They are saying that they can nominate anyone from anywhere, my lord.
Right. That's it.
And my lord, lordship has seen page 24, my lord. Maybe A, B, C are not in preferential order, my lord. Even I accept that, my lord. But C in itself is in a preferential order, my lord. Which says that electoral officer from Meghalaya, if not available, in my rejoinder, my lord, page 24. First is Central Election Commission, second is State Election Commission, my lord, and third is Chief Electoral Officer. Page 24 of rejoinder, my lord.
Yes.
Maybe A, B, and C are not in preferential order, my lord.
Yes.
Even if I say that, my lord, but C in itself is in a preferential order, my lord. C says a former electoral officer of the state.
Yes. No, we've seen that.
In case such person is not available.
Right.
So they cannot jump straight to note of C, my lord, without first exhausting the C, my lord.
Yes.
My lord, this is the case where the entire integrity of the electoral process, and my lord, as I submitted initially also, my lord, we are not, if your lordship can appoint any, or maybe our retired Chief Justice, my lord, as an electoral officer, or anyone, my lord, we are okay with that, my lord. And fresh elections, my lord, is a very short election, 15 days process, my lord, that can be directed.
Yes. Only one thing, when can we generate the judgment? Yes. Really, because I'm short of private secretaries also. That is the
only thing, lordship will take care of the interim order. That interim order is directed for postponing of election till 19th, my lord.
Yes.
I'll leave it, lordship.
Much obliged.
We'll pass order.
Much.
Sure. Wait, I call other matter. We'll sit till 2. Call up other matter to Contempt. Thirteen of the mean list. Yes. Yes.
For compliance today.
Well, complied. See, they should understand also. See, they cannot. Darbar can't sit on top of the decision of the.
But there are environmental issues and other.
See, that comes later.
That will take care.
See, that is just the initial stage. You have to make them understand that.
It's only for lease.
It's only for registration of a lease, my lord. Then thereafter there are statutory bodies, my lord, who will look into the other issues.
Yes, no objection certificate dated 15 September 2025 has been produced by the learned Senior Counsel of the NORC today. Accordingly, the contempt is purged.
Then we close.
The same is closed. Yes.
I'm handing over to Mr. Gautam.
Yes. Because see, I was going to say that to that headman yesterday, but I said you should explain it to him because it's not. It's the initial stage.
I explained
it's a
to them.
Process. That bottling plant started when it's just started construction. What are you going to do? Yes. Yes.
Deep.
Yeah. A copy to be brought on record.
Yes, my lord. I'll bring it on record.
Yes.
Original I'm handing over to Mr. Gautam.
Obliged.
Item
I'll file it up. Obliged.
12.
Good copy.
Yes.
Yes, ma'am.
Your Lordships, in this we have to file a list of witnesses.
Where's the list?
Your Lordships, I'm requesting for some time, Your Lordships.
You put an application. You put an application. You tell your local council put an application. Mr. Pala put an application. Yes. For the reasons stated. Yes.
Your Lordships, the matter may be listed after vacation then.
There's no more time. It will be after vacation only. Yes.
Please, Your Lordships.
Yeah.
14. 14.
My lord, we have obtained the instructions. After he received the letter from the department, he met the director, and director informed him that he has to sign the undertaking for signing the paper form, so that he will not. They say that there is an overpayment of salary to him. Now, it is not the case, my lord. The case is pending for the pension, my lord. He retired from 2019. Till this pension is not settled. Therefore, he approached before this court. Now, the department did not invite him to sign the paper for releasing the pension. They are inviting him to sign the IPS form. And they said that overpayment is there, we will recover it. So, Lord, to let the state file an affidavit.
Yes, Mr. Pala praised that that further, how much time?
2 weeks, will be after vacation. After vacation, I'll tell.
Yes, for affidavit, this accordingly. So it's also noted that Mr. El Sanreso has submitted that the communication dated 4/12/2025 is not for finalization of pension,
Yes.
but for
Yes.
signing of other papers collected with release of excess salary, with regard to excess salary being paid. Yes, accordingly. Yeah.
15. 15.
Wait, please, Your Lordship.
Lordship,
Lordship,
Mark sheet.
yes, Your Lordship. Lordship, on the last date, I had placed 2 judgments, and thereafter, Your Lordship had asked the respondent as to what are the details of the candidate who had been considered for the same category. However, that had not been placed on record, and that's when the hearing was concluded. However, Your Lordship, I seek to place some other judgments as well before Your Lordship in support of my case.
See, now that if you go by all the other judgments passed with Supreme Court also, once the instructions are there for the examinees to follow,
yes, Your Lordship.
If you don't do that, you even shade wrongly, there's no question of, even compassionately also we can't. We understand your position, even the court can't accept the discretion. In one case, I think that's come up from which High Court, went up to Supreme Court said no. Even though the High Court passed the order exercising discretionary powers of compassion, that inadvertently, as in your
Mistake
case,
has been made.
instead of shading whether you're a sports person, you shaded you're a non-sports person.
Lordship, there's one judgment on
Then
the...
we'll argue it. You argue it afterwards, after vacations, yes.
Grateful.
This is a matter for final arguments after vacations, yes. But that is the law. There's there's a judgment also. I think it's
2022, Your Lordship.
yes, Hemant somebody.
Mahendra Singh.
No, it's not a judgment also. But I can't recollect right now. I'm very bad with names, yes.
I'll go over it, Your Lordship. Grateful.
My lord, we have taken the steps. We have taken steps, my lord.
Then?
And my lord, Assam Rifle has filed one affidavit also. We are in possession. My lord, there they have categorically stated that they have never given any NOC. In fact, NOC was once asked, but they have denied giving the NOC.
New association. Is that correct?
Yes, my lord.
Then they are.
My lord, what they did, my lord, from Palakkad district, they asked, they would to try to register the society there, my lord. The Palakkad district register society asked NOC from us. We said we are not giving an NOC.
How have they registered?
They left their application. They went to a
another
different
place.
district, my lord.
They have concealed the fact and they have registered, my lord.
And there they somehow managed, my lord.
Then we have to have them before us. Now we're not here. You ensure that they served.
My lord, I believe this should be. We have taken the steps. So.
Their return is this is their respondents number
3, my lord.
3
Society.
Yes. Now Arisa is the legitimate one.
Legitimate one. We have
Yes.
made them a
Now, yes,
performer respondent. They
Yes,
have been
and
served, my
then,
lord.
I'll appear for them also, my lord.
Okay, number 6.
Number 6.
Yes,
performer.
Dr. Muzika has submitted that he'll be entering appearance. He'll be appearing also for respondent number 6. As such, service for number 6 is complete. However, office note indicates that the service report on respondents number 3 to 5 is yet to be received. Petitioner to obtain status before the next date and to file affidavit necessary. Then we'll hold them up. Yes. List out of vacation.
17.
But you obtain status and file affidavit before the reopening if possible.
My lord, we'll file it before the opening. We'll get a status.
17.
Obliged, my lord.
But how is that possible? Doing this?
They're using Assam Rifles name, my lord. Assam Rifles
This
is
is very dangerous. This is.
My lord, in fact, they have also
And
gone.
you're fooling poor ex-servicemen.
Yes, yes.
My lord, in fact, outside the domain of this writ, they have also gone on to file a suit challenging the authenticity of ARESA and asking the court to dissolve ARESA's registration and transfer all the funds of ARESA to them.
Must be some mastermind behind it. Yes. Next matter. Yes.
17.
Highly obliged, my lord.
Yes, Mr. Sangma. What's the matter about?
Here, my lord, with regards to the payment of the bills.
Yes.
Lordship,
They were supposed to come with instructions, Your Lordship.
my lord, our limited instruction in Lordship is that the payments has not been made because some guidelines has been issued, my lord, by the ministry. Your Lordship's.
Oh, it's because executive committee has changed.
No, my lord.
Then
There's some guideline, my lord, issued by the
you
ministry.
file
of-
affidavit.
Your Lordship will play that.
But yes, Mr. C.C. Sama submits that the non-release of the bills of the petitioner was in view of certain guidelines issued by the Ministry of Home Affairs
Jal Shakti, Lordship, Government of India.
by the Government of India. He is allowed to file affidavit. He is allowed list of application for affidavit. Yes.
All right.
18.
You rise up to enough orders. Enough orders here. नहीं ना? Yes. Yes, Mr. K.P. Barasaji. Yes. What happened here?
They were to take instructions. Yes, my lord, I have sought instructions. My apologies, my lord, I missed this case. I have sought instructions, my lord. My instructions is that the election was free and fair, my lord.
No, my lord, there was no election only. This is a how.
Yes,
Well, let them file an affidavit to the effect.
Admits that the reconstituted VEC was the proceedings, the election for reconstituted was for free and fair, and there's no discrepancy. So he prays him allowed to file an affidavit, bring this on record. Yes, he has allowed this certification here.
Obliged, my lord.
Other matters will take after lunch. Any hearing matters, any urgent hearing matters, as we adjourn them. We'll not take hearings because we are short of time. Yes. Any very, very urgent matter?
There's one matter, my lord, item number 23. Lord, we were thinking that we'll conclude it today.
The matter can be
subject to-
closed.
What
also.
matter is that?
That is regarding the freezing of account, my lord, again.
Lordship, in this matter,
The one matter only.
Your Lordship, in this matter, the investigation was no longer carried out because the respondent bank has already claimed, has already explained that they had acted on the directions of the MHA portal. So the FIR lies against the MHA portal.
MHA portal?
Yes. The Home Affairs portal.
We are which bank?
Therefore the bank.
HDFC. We have acted on the order of the Kerala CGM from Kerala. So we acted on that order.
Frozen the account.
No, we have taken that money and
They have recovered the amount, my lord, without my knowledge, without any notice to me, my lord, without even hearing
freezing
me.
the account. That's all.
Defreeze the account.
We'll do that.
The only thing, there are certain things, my lord, I would like to bring to your lordship.
Since the
notice.
amount deposited to your account has been repatriated.
Yes.
Then?
No, oh, here, my lord, the issue is, my lord, they say that my account is clocked with certain doubtful transaction, my lord. I checked up my transaction, my lord, there is no such transaction which they describe in their affidavit. I don't know on what basis they have recovered that amount from my account.
Then we'll take it after
We'll take it.
lunch. But it'll be, yes. What other, huh?
Only 23.
How many orders are there? We take up the remaining orders and one hearing matter after lunch.
The other hearing matters.
Other hearing will adjourn after vacation. So other information of parties, these are the vacations, except for 23.
33.
How much?
Item number 1. May I have the chance of mentioning a matter, even though my lords have recused itself from hearing the CMJ matter, but now no coordinate bench is sitting. This is a urgent matter, my lord. If it can be listed tomorrow, my lord.
You make a mention for the CJ. But the bench will be there tomorrow.
For the tomorrow's last working days, my lord.
It can be mentioned.
Very
Last working day will have more opportunity of being listed.
Very well. I'm so grateful. I will take my chances tomorrow.
Item number 1.
Your Lordship, let this matter come after vacation, Your Lordship.
Sat specially at 3 o'clock for you to hear this matter. Didn't even eat my lunch, yes. How you compensate the court for that?
No objection.
What no objection? Okay, yes, on the prayer also after vacation.
Your Lordship, may status quo order be maintained, Your Lordship.
Item number 2.
Status quo interim order when he shall continue next 8 days.
Item number 2.
Yes.
Your Lordship, with this matter, so I asked after vacation.
What's the matter about? Is it for some
Compensation
effective orders today?
No, Your Lordship, it's for hearing, admission hearing.
It's for admission hearing.
Yes, Lordship.
Any interim orders are there? Oh, on upon implementability. Okay, yes, this matters on the request of MS also. This matter application is
3.
Please, Your Lordship. Your Lordship, there's a similar appeal pending.
My lord,
for
item
the
number
bench.
3 and 4, my lord, state has preferred an appeal, my lord, which is still pending before the division bench, my lord.
Which is this matter? What is the matter about?
This is the regarding 5 employees, Your Lordship. Payment.
Work charge employees, my lord, entitlement to fifth pay, my lord.
Has submitted that appeal is pending consideration. Before the division bench, this is matter after vacation.
5.
Lordship, I have gone through the application for business
You have no
contracts.
objection.
I have no application there because it is certified copy. It should be in the course.
You take down this from this case number 15/2025. It be Miss Case FA. Arising out of. This is an application for condoning the delay of 234 days and preferring the connected first appeal. Stop. 274 days of time. Stop around. Mr. Anna Chaudhary appearing for the respondent, sole respondent, submits that he has no objection to the condemnation, to allowing the condemnation application stop. This court also on here submissions and also on perusal of the grounds as set out in the application, wherein sufficient causes are made out. The delay of 230 days is only condoned. Stop. Register to diarize and list the first appeal. Diarize, they do D, diarize, and this is the first appeal. For listing after vacation.
6.
I look. Miss Case, love disposal.
Please, Lordship. Yeah, government is supposed to fight the affidavit. It's supposed to be on board. The private respondent, they have filed the affidavit. 1 to 3 have not verified.
I pray for some time, Your Lordship.
You are for 4.
Yes, no, sir. On number respondent 5.
Number 5.
Yes.
You are A. Khatni. What's your name?
My name is Rosalind Marak. Rosalind Marak.
What for 4? Nobody is here. Who appeared for 4?
Is it government or not?
Number 4 is government.
Respondent number 4 is the government. Actually, is 1 to 3. With this one, I forget it. Accountant General. Accountant General. Yes, Pasha.
You have filed affidavit.
I'm praying for
You have already filed affidavit.
Pasha.
Yes, MS said inaugurating 1, 2, 3. Yes, for the 2 weeks time to file affidavit. Prayers allowed just after vacation. Stop. MS Sunsur present on behalf of fund number 5. None appears for 4.
Muscular Lordship.
7.
May I please, Your Lordship? Lordship, I pray for some more time, Your Lordship, to file rejoinder.
How many times you played rejoinder?
It's the second time, Your Lordship.
Yes, final opportunity granted the petitioner to file rejoinder just after vacation.
File the blessed Lordship.
8.
It seems the petitioner yet to file the.
Who's appeal? Did not appear for last year also?
So because again, this I am Lungda.
Yes. Will dismiss it for default today also when the matter is called out. None is present on behalf of the petitioner. Stop. In the event of no representation next year, the matter shall stand dismissed.
9.
Please, Lordship, this matter, the government is supposed to file the affidavit, MECR, and also the Deputy Commissioner. The Deputy Commissioner, on the last occasion, they said they would not be filing the affidavit, but the main respondent is MECR.
Yes, MECL is the main respondent, main participant.
Where is the council MECL? Where's MS? MS.
2 weeks time to file affidavit.
Arkolni. Yes. Where's she?
Only here.
Just file affidavit.
Not yet, man.
Not yet.
So time is taken by respondent
Yes.
2 and 3. The contesting respondents to file affidavit on 27 11 2025. The same is yet to be on board. It's after vacations. It's expected next date they are safer by next date average have been filed.
10.
Must be Lordship. Here also the government, the private respondent have filed the affidavit. Government have not.
Your Lordship,
Number 5 they have filed.
Your Lordship will be filing an affidavit tomorrow, Your Lordship.
What about number 4?
Number 5 and 4 they have.
Who's number 4?
Number 4 is Prasa Prasa. This Accountant General. Prasa.
What is her name you say? Should know your colleague's name also, yes.
Prasa.
Courtesy also demands that you should know the name of your colleague, the correct name.
Yes.
And so your MSL in the GA correspondent 1 to 3 submits affidavit will be filed by tomorrow itself.
Tomorrow, Your Lordship.
You already filed yours.
Yes, Your Lordship.
Yes, so present we have number 5. None appears for span number 4. List after vacations of further orders. Yes.
Lordship.
About Your Lordship.
11.
What's Lordship? Here also the 1 to 5 they are supposed to file the affidavit. Private respondent number 6 has already been filed.
1 to 5 not filed also?
Yes, 5.
1 to 5 KP Bharatsaji.
Yes, 1 to 5.
Your Lordship, I'm praying for some time on behalf of Mr. Bhattacharjee.
What's the matter about?
It is regarding pension, my lord. 2 wives, yes. So I'm the first wife.
But then the respondent number 6 is the accountant general.
No,
Yes, Your Lordship.
yes.
The other wife been implemented as party.
Other wife, there is only one more. Number 6 is number 6 is accountant general.
You know, implemented the other
1 to 5 is the state, Your Lordship, and 6 is the
MSA
accountant general.
for 1 to 5 page 1 there are 2 weeks time to file affidavit. No representation to have number 6 list after application.
About Your Lordship.
12.
Lordship, the state has filed the affidavit, Lordship, here.
Lordship, I am praying for some time to file our affidavit.
Yeah, for number 7.
7, Your Lordship.
May I please, Your Lordship? Lordship, in the meanwhile, I'll give my rejoinder to respondent number 1 to 5, Your Lordship.
When did you file your affidavit?
My lord, this week, Lordship. Last week.
You have not filed your affidavit?
Not yet, Your Lordship. We will file it after application.
MS M. Rahman, the Red Council Petitioner, please be allowed to file the joint of the affidavit filed by the state respondents 1 to 5. Stop. Mr. E. Ahmed,
yes,
correct? For number 7, whoever has paid for further time to file the affidavit. Both the prayers are allowed. None appears for response number 6. List of applications.
Obliged, Your Lordship.
Be it pleased, Your Lordship. Your Lordship, I beg to mention that I am appearing for respondent 5, 6, and 7. Your Lordship, I humbly pray for some time.
Why?
There are some documents dating back to 1992 that I am required to examine and bring on record.
Any objection?
No, Your Honor.
No objection. You are Mr.
W. Dakar, Your Lordship.
For already filed. Yes, yes, I'm not going to record. Show Mr. Duda Khan, behalf of 57, pays for further 2 weeks' time to file affidavit. Stop. The date objected to us. Order number 8. None appears number 8.
We have already
File your
given
affidavit,
affidavit
yes.
for service of copies.
Number 8 is whom? Is EM or somebody? Village Implementation Monitoring Committee. No? And it's allowed for a fixed time to file affidavit stuff. There's no representation on behalf of the respondent number 8, though notice has sent this list of the locations. Affidavit transfer for the orders.
14. We have already filed an affidavit in this case, and the petitioners were supposed to file the rejoinder.
May I please, Your Lordship? In this matter, we are not filing a rejoinder, Your Lordship. So I humbly pray Your Lordship may be pleased to post this matter for hearing, Your Lordship.
Tomorrow?
So after vacation, Your Lordship.
Yeah, Mr. S. Goenka submits the rejoinder file to the affidavit filed to the respondents. This is matter for hearing after vacation.
After the vacation.
Much obliged.
Obliged, Your Lordship. 15.
Please, Your Lordship. Lordship, I'll be filing the affidavit tomorrow.
2 and 3.
2 and 3.
What about 1?
We're not finding, Your Lordship.
MS Lalu for 2 and 3 submits that the affidavit in behalf of the respondents 2 and 3 will be filed by tomorrow. Yes, just after vacation, rejoined of any.
Much obliged.
16.
Lordship, I'm praying for some time.
You're opening for whom?
2 and 3.
Was 2 to 4? You have to file with you.
No, Lordship, this matter is also just to age cover now.
Out here, this name is shown as MS Bank. Number. See, 234 is the MECL.
Yes. Lordship, then I'll 2, 3, 4.
Is endorsed Mr. Karwanlang?
I'm not sure, Lordship, but I'll cross check.
So I'll say you mentioned behalf of whom?
Of A.H. Karwanlang.
But the name shows bank, so who? We'll just write. Yes, MSS Lalu. All right, appearing for 1, 2, 3, and 4. Please forms right for the 2 weeks time for affidavits. Is thereafter. Yes. The court doesn't use it, but then.
17.
Lordship, affidavit of service of notice on the respondent number 4 and 5 is complete, and I filed an affidavit also to this effect.
What about
4 and 5, Lordship.
Number 6, I'm appearing, Lordship. I'm trying to file an affidavit.
You already appeared since 9th of December.
Lordship, there was some time taken to execute the Wakalat.
What about
Your Lordship, I'm praying for some time to file an affidavit.
MS Iblaf 123 and Mr. S. Dev for number 6, pray for further 2 weeks time to file affidavits. It is noted that though respondents 4 and 5 have since been served, there is no appearance on their behalf. This is matter of provocation. Preferred order.
23.
Yes. So this matter concerns the freezing of account. What had happened in this case is the petitioner herein is operating a bank account with the HDFC Bank. Now one fine day she comes to notice. It comes to her notice that she is not in a position to operate her account. On inquiry being made, she was informed that there is a certain police case referred somewhere in the south of the country, in Kerala, and pursuant to which the account was freezed. Now, here on 2 occasions her account was freezed. One, on the basis of a complaint by the Kerala police, and the second debit freeze happened on the basis of 3 complaints that were lodged in the MHA portal. Now, insofar as the first debit freeze is concerned, that was, of course, on the no objection being granted by Kerala police, that was, instructed to be defreezed. I'll take your lordship to the affidavit filed by the respondent. May kindly have page 23. Respondent number 9. The state did not file because they are just a formal party in the case. Of course, the other state police did not participate in spite of the notice being served on them. Therefore, my lord was pleased to direct ex parte proceeding against them. My lord, may kindly have page 23, my lord, of the affidavit filed by respondent number 9. Yes. To so and so, the bank account number so and so was frozen. This is the bank account which we are concerned with, was frozen by you on our earlier notice as per crime number 1523 registered in our police station. In response to our summons, the account holder provided proofs and documentation regarding this account. We found the clarification by them to be satisfactory regarding the disputed transaction related to the case. Therefore, we are providing our NOC to remove the debit freeze marked on this account. Please treat this matter as most urgent and inform us the action taken. So, pursuant to this matter, it was debit. Debit freeze was removed. Now, lordship, after this, we went and approached the bank again to remove the debit freeze. That was not done. So, apparently, on a ground matter, there are other complaints lodged in MHA portal. There are 3 different complaints they state, my lord, has been lodged in MHA portal concerning this very account number, my lord, that you also will find at page 11 of my writ petition. Paragraph subpara number 13, my lord. Page 11. Subpara? Yeah, subpara 13, my lord. Page 11? Yes, of my writ petition. Oh. September 13. Yes, acknowledgement number so and so, my lord. This was by this was done by Telangana police station. Lord, then the acknowledgement number 2, my lord. This was done by Andhra Pradesh police station, my lord. And the third one was by Tamil Nadu police station. Now, lordship, as there was no notice issued to us, even concerning this very transactions, my lord, or this very complaint, my lord, we were constrained to file a writ petition before the Honorable Court, and notice was issued to them. They did not appear even in spite of the notice. Now, meanwhile, what had happened, my lord, the Tamil Nadu police station, my lord,
on documents being provided by us, they issued a letter, my lord, which you also will find at at page 6 of my rejoinder, my lord. Yes. This is by Tamil Nadu, Trichy city. This is by Tamil Nadu Police Department. In the above reference regarding MHA have frozen the account number so and so. In the inquiry, I found that the mentioned account holder has received money from selling her USDT for the amount of rupees so and so in the 3 layer. The account holder has given clarification about this transaction and also shared all the document. Hence, it is requested to unfreeze and remove the lien on the amount of rupees so and so in the account number so and so. Once the account is unfreezing, kindly inform us in the mail ID so and so. Now, having provided all the document, this was again the lien was removed from my account insofar as Tamil Nadu is concerned. Telangana, my lord, and Andhra Pradesh, Andhra Pradesh and Andhra Pradesh, and the other one is Andhra Pradesh and Telangana, my lord. Telangana, my lord, they did not, they have never issued anything to us. And my lord, therefore, your lordship was pleased to direct ex-party proceeding against them, my lord, and that speaks of their conduct insofar as this proceeding is concerned. Now, meanwhile, my lord, what has happened? There has been some deduction from my account again. Now, lordship, that I came to know only, my lord, once they filed the affidavit. My lord, it appears that after having defreezed my account by under the instructions of the Kerala police again issued another notice to the bank, and the bank defreezed my account again. And pursuant to that defreezing, my lord, there has been some order from the CGM court in Kerala, and therefore, and thereby, my lord, whereby my account, some amount of recovery has been made from my account without my knowledge. Now, my lord, I have no, insofar as the order passed by the CGM is concerned court in Kerala is concerned, I have no say. What I'm only saying is, my lord, when this action was done at the behest of some court order, my lord, this honorable court was already in seize of the matter. My lord, the bank, the least could have done was could have informed the concerned court that the Honorable High Court is already in seize of the matter. Therefore, nothing could be done unless the matter is dealt with by the Honorable Court. That was not done so, my lord.
By SDFC?
By the SDFC. Now, my lord, here this is something which is which I feel the bank should have been little proactive, because all the while, my lord, the notices concerning the freezing and defreezing has all been issued to bank, not to the person concerned. I have never been in loop insofar as these transactions are concerned, my lord, in so far as the proceedings are concerned. My lord, here everything has happened before me, yet I am in a position where I am not being able to do anything. Now they say that they have done the recovery on the basis of some orders by the CGF.
Where is that?
No, that order, of course, is not a part of record, but that was
that reduction. Where is that? Is coming affidavit?
No, my lord. They say that that has been
other subsequent documents. You have to find affidavit, Mr.
No, my lord. I'm fine with. I'm only concerned with the defreezing now, my lord. Insofar as recovery is concerned, I have no. Like I said, my lord, since it's been done with the help of a court order, I have nothing much to say on that. The other aspect, my lord, I don't fail to understand why I have been implicated in this entire quagmire. Why I'm saying this is, my lord, may kindly have the affidavit filed by the respondent number 9. My lord, I'll take your lordship to page 24 onwards. There are certain transactions which appears, as per them, my lord, appears to be doubtful.
Page number 9?
Yes, 24, my lord, page number 24. Respondent number 9 affidavit, my lord. This is a statement given by them. The doubtful transaction I'm talking about, my lord.
Yes.
It was done by the name of Najla Sahar Fatimullah, page number 24. In 25, my lord, the bottom entry concerns my account.
25.
Page number 25. The bottom account, my lord, may kindly see account credited 5001, that is 86757 is my account. Now the disputed amount is 700. My lord, may kindly note the date 23/2/2024. Now the other transaction we are concerned of, my lord, your lordship will find at page 31. 31, my lord, the serial number 8. Serial number 8, my lord. This is by in the name of Bandla Mudi Anusha. That name of the account holder, my lord, is reflected in page 30. The transaction I'm referring to is at page 31. Serial number 8, my lord.
Where is that?
Beg your pardon, my lord.
Page 30, where is the name of the account?
At page 30, my lord, on top.
Bandamali Anusha.
Anusha. Yes. My lord,
The
the
complainant
transaction.
details, the complainant.
Complainant detail.
Yes.
Now, my lord, serial number, sorry, page number 31, my lord, the transaction is serial number 8 we are concerned with.
Where is
This is my account. In page 31.
Your name's not number 8. Credit card is reported in this is your number is not 8.
My account number is there, my lord.
86757?
Yes, 86757. The
Doesn't
disputed
9 is number 9, not number 8.
It is 8, my lord. 9 is the other one.
9 is there's a line.
Maybe my lord, because it is done in that way only. I think it's 9 now. And the disputed amount is 50,000.
No, it's amount is 70,480, 15/2/2024. You read it properly.
Yes, my lord. If we take 9 as a concerned transaction, my lord,
Your number is
it is 70,484. Now the other transaction again, my lord, lordship will have page 33.
No, that's not your number. Your account number is
that
50187.
Yes.
Amount credited to 86757. This is 86757. Okay, yes. Right.
So, my lord, then lordship similar transaction your lordship will find at page 33. 33, my lord, and again 34.
Your amount are credited to your account.
Yes. No, they are saying that this amount was transacted or was my account was used for transaction of this fraud transaction. Now, my lord, I have annexed my statement details, my lord, in my rejoinder affidavit. May kindly have page 7 of my rejoinder affidavit, my lord, because all this transaction, my lord, concerns the doubtful transaction, my lord, concerns from January 2024 till July 2024, my lord. I have reproduced my entire transaction starting from January 2024 till, my lord, 1st of July 2024. My lord, the transactions nowhere mentions, my lord, the name of, do not find mention anywhere.
In that, as per a sheet given.
As per the sheet given by them.
How is it possible?
That is something which is
given by the bank.
This statement I've taken out from the bank itself, my lord.
Where's the account number given? Of his account?
The name is there, my lord. The account number.
What's the account number? In case it's a different account. This is 86757. Where does it show 7 accounts for Mr. Marpan is for 86757 this account?
Yes, that's the only account I operate with HDFC.
Yes.
Yes.
This statement, this page number 7, the account number is not here. The lordship, it's not there. So we do not know whether the statement was given by the bank. That I have to cross check.
You get a statement.
Better get the statement. Lordship, as far as the order from CGM is concerned, kindly come to order dated, Your Lordship's order 14 August 2025. Your Lordship have already taken that on board, the order of the CGM from Kerala. Lordship. Order dated 14 August 2025. Lordship. The affidavit, our affidavit was filed before that. This is a subsequent development. Lordship.
14 August 25.
25. Lordship. This was passed in a missed case here. Actually, we will not be there in the writ petition. It's a missed case.
Are you going to give in-depth hearing, Mr. Thapa?
Well, insofar as the money is concerned,
Because it's very interesting. Because if your suggestion is correct, that is reflected in that portal, whatever that that's annexed by 1 that is on the, how will that figure in your account?
absolutely, well, that is something which even
Very
baffling me.
mysterious. Yes.
14 August 25, Lordship, the order.
Yes.
So, Your Lordship, by this order, Your Lordship had taken on board the order of the Kerala CGM in Kerala, Lordship, whereby the petitioner is the respondent number
What was
5.
supplied to you then?
He supplied me, ma'am.
Yes.
That's why I'm saying, my lord, insofar as this
What happened after this in this case? Nothing happened.
We acted on this order. We deducted the amount 45,500, which is the amount which is supposed to be recovered as per this order. Now, when the branch received this order, they have cross-checked with this case which is here. Since there is no stay, we have to act on this order from this court. For that reason, we had to act on that order.
This order for the court before you release the amount.
No, because
they released it and then
knowing that is why.
Lordship, the thing is that
I'm very unhappy the way they're conducting the business. Have you paid that amount, 90,000?
which I have already given them instructions. I'm just waiting for the.
Will drop Contempt.
Lordship, in this case, there's nothing remains. Lordship. We have acted on an order from the Kerala police. We have freeze it and defreeze it, and then in the MHA portal it was there. It was our duty to check the portal. When there's a fraud, online fraud, we have to act on that. So we have freeze it. And now this order from Kerala, CGM Kerala, we have to this giving us clear direction that we have to deduct this money and transfer it to this complainant. This case is still pending. They are also a party in this case. Respondent number 5.
Never received any notice from the court.
So the only thing left is to defreeze the account and for them to go and contest that matter in Kerala.
You defreeze our account for now, but then we will keep the matter pending.
We'll defreeze it. Will take us at least 4 to 5 days.
That will suffice.
And the other thing is that respondent, the Kerala police is very important for them also.
There's no impediment for defreezing the account of the writ petitioner at this stage. As it is submitted that the disputed amount has since been recovered, has been repatriated by the respondent number 9 bank under orders of
CGM Kerala.
CGM. Just give the name of the court.
Todu Ruja. CGM Todu Ruja Maladi. She is Srimati Sindhu Thankam.
Spelling is THODU.
It is at Kerala.
Kerala state.
The district, I guess, is a Thodu Ruja.
Thurupuja.
THODUPUZA. ZHA.
Very easy to say, but if you are spelling.
THODUPUZHA.
And
what is it? 2 CGM or you write it down.
And also, Lordship, the other thing is the respondent, which is the Kerala police. They also have to be, because they are the person, they are the authority who would give a clear picture to whatever is happening.
They have appeared.
They have not appeared, but it's going ex parte against them. It's very important, at least an attempt may be made by the petitioner to at least get them on board. Maybe from the police, from the state police also can do something. The SP would have some contact.
The has since been repatriated under CGM so and so stuff. Though is submitted by Mr. Esthapa that this seems not to his knowledge. The instant matter will receive further consideration by this court, especially with regard to the status of the other respondents who have not appeared in spite of service of notice. Accordingly, I directed that the account number being 81
501 003361 86757. It's at page 8.
of your petition.
Yes.
Shall stand be freezed. Yes, for the hearing after vacations. We'll go to the bottom of this. I mean, this bank, they have to be some how you serve your customers, not be looking for investments. That's it.
Right.
Right.